All right, welcome back. Today, we're going to hopefully get caught up on Scofield versus Guillard, the TikTok psychic defamation case. So, for those of you who are new, I'm Joe. I'm an attorney. I'm licensed to practice in the state of Utah. This litigation is happening in Idaho. So, quick recap. Basically, the last couple of videos have concerned the fight over Ashley Guillard, the so-called TikTok psychic, was trying to subpoena virtually all of Professor Scofield's Facebook instead of just, asking her for it because, you're supposed to ask for discovery from the other party. But she says asking her would have been useless because she wouldn't have given it to her anyway because it would have proven that she's the murderer. So she had to subpoena it. But either way, Professor Scofield fought that. Her motion was granted. Professor Scofield's motion was granted. So yeah. And then we had Ashley Guillard's convoluted mishmash of, motion to reconsider the dismissal of her counterclaims, but also to dismiss Professor Scofield's claims. And she kind of argued both things at the same time, like, you couldn't have dismissed my claims because you don't have jurisdiction, and you have to dismiss because you don't have jurisdiction. But it was a mess. So today, assuming we get through everything I want to get through, we will be caught up. So let's scroll down in the docket, and we are doing docket number 56, which is the motion for partial summary judgment by Professor Scofield. So this looks intimidating because there's the main document and 21 attachments. Most of these there's nothing to see because it's exhibits that are TikTok videos that Professor Scofield submitted by USB drive, by thumb drive. So there's nothing to see anyways. I mean, click on a random one. Oh, sorry, that's the cease and desist. We don't need to see those either. But, Exhibit H, TikTok video dated 12/1/22, provided separately via flash drive. So there's a whole bunch of those. They don't matter to us. They do matter to the court because that's the evidence that, is being presented for the summary judgment motion. So, and then we have Ashley Guillard's Halloween response, her opposition to the summary judgment motion. And that's going to be aggravating. Yeah, we'll call it aggravating. So, where does that leave us from here? Well, Professor Scofield gets to do a reply brief if she so chooses. I expect she probably will because that's been the pattern so far, you know. So I expect them to keep to their pattern. And once that's in, we're waiting on, frankly, a decision on the motion to dismiss that we discussed last time. That's going to be denied. And then we'll be waiting on the motion for partial summary judgment, the ruling on it. And it should be granted. It should be granted. If Ashley Guillard were represented by a very incompetent attorney who submitted everything exactly like Ashley Guillard has and has proceeded exactly as Ashley Guillard has, it would be granted, no question. It's just she's pro se, and judges grant too much leniency to pro se litigants, especially considering they're supposed to construe their pleadings liberally, but hold them to the rules strictly. Well, we've seen far too many times where they're not held to the rules strictly, and I hope that this isn't one of those times, but I'm not going to be surprised if it is. Of course, like I said, if she were represented by an attorney who did exactly this, well, she'd have a malpractice claim against that attorney, and that attorney's malpractice insurance would be paying at least part of the judgment against her, probably. But she's pro se, so, you know, there is no such thing as ineffective assistance of counsel for her. But I think for today, the best place to start before we even go into the pleadings is the federal rules of civil procedure. Because, you know, sometimes we have to learn something. And there are a few things that we need to learn today. And so the last couple of videos, we've discussed the rules pertaining to discovery, Title V of the Civil Procedure Rules. And the relevant ones today are Rule 33, interrogatories, 36, and 37. So interrogatories, basically, they're questions you ask for discovery, is the easiest way to describe it. And so generally you're allowed 25 interrogatories each, unless otherwise stipulated. And so scope: an interrogatory may relate to any matter that may be inquired into under Rule 26B. And so 26B, remember from last video, is the allowable scope of discovery. An interrogatory is not objectionable merely because it asks for an opinion or contention that relates to fact or the application of law to fact, but the court may order that the interrogatory need not be answered until designated discovery is complete or until a pretrial conference or some other time. So it's, you basically, that says, hey, you can ask questions in interrogatories that you wouldn't be able to ask a witness on the stand because, the rules of evidence wouldn't allow it, but you can ask it in an interrogatory. You can ask for a lay opinion. You can ask for a conclusion of law. But yeah, so, and the answers and objections. The responding party, the interrogatories must be answered by the party to whom they are directed, or if that party is a public or private, that doesn't matter because she's not an artificial person, or she's the party to whom they are directed, so she has to answer them. You have 30 days to respond after being served. Each interrogatory must, to the extent it is not objected to, be answered separately and fully in writing under oath. Objections. The grounds for objecting to an interrogatory must be stated with specificity. Any ground not stated in a timely objection is waived unless the court, for good cause, excuses the failure. And they've got to be signed. Use An answer to an interrogatory may be used to the extent allowed by the federal rules of evidence. So basically it's saying, hey, that this is out of court sworn testimony, sworn answer, but it's not subject to cross-examination. So, it's probably hearsay, but you might be able to use it as a prior inconsistent statement as allowed by the rules of evidence, or, it's statement by a party opponent. So it might be usable, period, by the other party. But basically the use in court allowed by the federal rules of evidence. And then you have the option to produce business records. So we don't need to worry about that. Next, and I think most important for today, is the request for admissions. So the scope: a party may serve on any other party a written request to admit, for purposes of the pending action only, the truth of any matters within the scope of Rule 26b1. So once again, within the scope of the rules of discovery, relating to facts, the application of law to fact, or opinions about either, and the genuineness of any described documents. And we don't need to worry about form. You've got 30 days after being served to respond. And then the answer: if a matter is not admitted, the answer must specifically deny it or state in detail why the answering party cannot truthfully admit or deny it. A denial must fairly respond to the substance of the matter, and when good faith requires that a party qualify an answer or deny only a part of a matter, the answer must specify the part admitted and qualify or deny the rest. The answering party may assert lack of knowledge or information as a reason for failing to admit or deny only if the party states that it has made reasonable inquiry and that the information it knows or can readily obtain is insufficient to enable it to admit or deny. And then there's objections. We don't need to worry about that. Effect of an admission: withdrawing or amending it. So a matter admitted to under this rule is conclusively established unless the court, on motion, permits the admission to be withdrawn or amended. That is a huge, huge deal. So if a matter is admitted under this rule, it is conclusively established. So you don't even, let's say this goes to trial. If something is admitted through these admissions, you don't even have to ask them. You just basically tell the jury, hey, these facts are already admitted. They can't be contested. They're done. And for the purposes of summary judgment, it's an uncontested fact. That's going to be important. That's going to be very important. So our final discovery rule we need to look at is the failure to make disclosures or to cooperate in discovery. Sanctions, Rule 37. So, and for those of you who follow the sovereign citizen stuff, I think that this is where sovereign citizens pick up one of their false beliefs, because often their beliefs have a kernel of truth, just not as they apply it. So with this, in general, On notice to other parties and all affected persons, a party may move for an order compelling disclosure or discovery. The motion must include a certification, so we don't need to worry about that. Let's see. Let's see. Okay. Section C is what we need. Failure to disclose or supplement. If a party fails to provide information or identify, failure to admit. That's what we need. C2. I should have read these in advance. It's, the rules are pretty dense. And it's been a while since I've read this one. But if a party fails to admit what is requested under Rule 36, and if the requesting party later proves a document to be genuine or the matter true, the requesting party may move that the party who failed to admit. Okay, no, I was wrong. We don't need that. Clearly, I should have read these before. It's been a while. But basically, what I'm looking for is failure to respond to requests for admissions means you've admitted them. They're deemed admitted, period. So, and I think that's where sovereign citizens get the, I sent the city, I sent the DMV my notice of being the private person and not subject to the laws of the state, and they never respond. They never responded. So, it's admitted, even though there is no actual rule of procedure for that because it's not a thing. So there is no sanction for failure to respond. Whereas in actual litigation, there is. So, and then finally, we have Rule 56, summary judgment. And basically, we're just going to look at A because we don't need to worry about the procedures for today. But basically, A, motion for summary judgment or partial summary judgment. A party may move for summary judgment, identifying each claim or defense or the part of each claim or defense on which summary judgment is sought. The court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. The court should state on the record the reasons for granting or denying the motion. So that's basically what summary judgment is. What you do is you put forward, you as we'll see, your statement of undisputed facts. Basically, both these are facts from both parties. They're uncontested. The non-moving party agrees with this fact. So, and if there are facts supporting each element of the cause of action that are undisputed, summary judgment should be granted because there's no actual dispute. So the case should be either dismissed through summary judgment or the plaintiff should win on summary judgment. So if the tables were turned and this were Ashley Guillard's motion for summary judgment in favor of the defendant, it's different from a motion to dismiss, a 12b6 motion, because it's a different standard. Well, I mean, the evidentiary standard is still the same. It's still preponderance of the evidence for this, so more likely than not. But basically what it is with the 12b6, what you do is you look at the complaint and you say, if all of these facts are true, if all of these allegations are true, if we take all of these allegations as fact, is there enough to bring this cause of action for it to move forward? If not, it's dismissed. If there are, it goes forward. And then you don't give it the benefit of the doubt anymore, because you only take it as true for the purposes of the 12b6 motion. Whereas with a summary judgment motion, you look at both sides. So it's basically you put a Venn diagram of the plaintiff's set of facts, their allegations, and the defendant's set of facts, their allegations, and you look at the middle section, the overlapping section, and if there's enough in that overlapping section to go one way or the other, then you grant it. You grant the summary judgment motion. If not, you go to trial, and then the trier of fact, either a judge in a bench trial or a jury in a jury trial, decides which set of facts are more persuasive. So summary judgment, we don't care about persuasiveness. It's just, if there's no genuine dispute. As we'll see here, there is no genuine dispute. Ashley Guillard will claim there is a dispute, but there is no genuine dispute of facts. And I hope by now you realize why there is no dispute of material facts. There's a reason I went through the rules first. So with that, let's jump into the documents. And the first document, I forgot that I did it in this order, but the first, we're not going to look at the motion first. We're going to look at this is, what? I think it's Exhibit A. But it's the plaintiff's first set of interrogatories, requests for production of documents, and requests for admission to defendant. So basically, this is her discovery request. And we don't need to worry about the first bits. That I don't care about the instructions to Ashley Guillard. I don't care about the definitions. I do care about the date. And it'll be at the bottom, I think, but that's fine. This 1010, that's just the Bates stamp. Basically, it's by the clerk for Exhibit 4. Well, docket 56-4. So that's for when it was filed for this purpose, not when it was sent to her. So we don't care about instructions. We don't care about formats. Still instructions. Okay, so interrogatories. These are the questions that they want answered. So interrogatory number 1. Please identify the name, address, and telephone number of each person known to you that has any knowledge of, or that purports to have any knowledge of, the facts related to the matters alleged in the complaint or answer, and describe the knowledge you believe each such person possesses. 2. Please identify every person you expect to call as a lay or fact witness at the trial of this matter, and for each such person, state the substance of the facts to which each person may testify. 3. Please identify every statement you have made that plaintiff had an affair with Kaylee Gonsalves, including without limitations the date of the statement, the audience, and the medium used to make the statement. Boy, she's going to have a lot of work to do that one. If she did it. If she responded to the interrogatories, I mean. 4. Please identify every statement you have made that plaintiff was involved in the murders, including without limitation the date of the statement, the audience, and the medium used to make the statement. 5. Please identify the number of times somebody has viewed a TikTok or YouTube video where in the video you state that plaintiff had an affair with Kaylee Gonsalves. 6. Do the same for videos about the murders. 7. Please identify all email addresses, TikTok accounts, YouTube accounts, social media accounts, or account on other online platforms you have used to make statements about plaintiff. 8. Please identify the factual basis for your contention that plaintiff had an affair with Kaylee Gonsalves. And number 9, do the same with the murders. 10. Please identify the date when you first said plaintiff communicated with Brian C. Kohberger about the murders. 11. Please identify the content of the communications you contend occurred between plaintiff and Brian C. Kohberger related to the murders. 12. Please identify the date when you first said plaintiff had access to a white Hyundai Elantra. 13. Please identify all reporters that you made a statement to about the plaintiff. 14. Please identify how much money you have made related to your statements about the affair or the murders, including without limitation, monies you have received from sponsorships or advertisements on your TikTok, YouTube, blogs, or other online accounts, tarot card and other spiritual readings for new clients, payments for interviews with the media, bloggers, or other content creators, or the sale of any other services or products. Ooh, that'll be an interesting one to see the answers to, if it's answered. 15. If you deny any of the requests for admission propounded herein, you don't ask interrogatories, you propound interrogatories. That's the verb used. We use strong words in the law. So if you deny any of the requests for admission propounded herein, or if your response to any of said requests is anything but an unqualified admission, for each denial and or partial denial, set forth in full detail the factual basis of each denial and or partial denial, and identify each witness, fact, and or documents, and or electronically stored information which you contend supports each denial and or partial denial. And then requests for production. So it's give us these documents, give us these things. Headphone over my hair, which was annoying. So request for production number 1. Please produce all exhibits you intend to introduce at the trial of this matter. 2. Please produce all documents and communications related to any matters alleged in the complaint or answer. 3. Produce all documents and communications, including without limitation, TikTok videos, YouTube videos, blog posts, social media posts, or other online content containing or related to statements you made about the affair or murders. 4. Produce all documents and communications that you contend prove plaintiff had an affair with Kaylee Gonsalves, and do the same about the murders. Produce all documents and communication that show how much money you have received related to statements you have made about the affair or murders. Produce all communications about this litigation that you have sent or received. 8. Produce all documents and communications that you reviewed or relied on to answer any interrogatory or request for admission in this litigation. And 9. Produce all documents and communications that you have received from any third party in connection with this litigation, whether by informal request, subpoena, or otherwise. So basically, if Facebook had complied with her subpoena, they're saying, give it to us. You subpoenaed Facebook. They gave you this response. Now give it to us. We want to see it. You've got to share it with us. And now, this might be the most important part of this document. Because I hope my hints have been strong enough. She didn't respond to the requests for admission. These are all deemed admitted for the purposes of the summary judgment motion. They'll be deemed admitted at trial too if it goes to trial, but it won't. But they're deemed admitted. Let me say that again. Ashley Guillard, by her silence, has admitted to each and every one of these. So when we read her opposition to the summary judgment motion and says otherwise, we can just cross that out because she has admitted them. Sounds fun, doesn't it? So, request for admission number 1. Admit that you have stated publicly that Rebecca Scofield had an affair with Kayla Gonsalves. Well, I mean, that's an easy one because she doesn't contest that one. That's admitted. 2. Admit that you have stated publicly that Rebecca Scofield was involved with the murders of the students. 3. Admit that plaintiff did not have an affair with Kayla Gonsalves. 4. Admit that plaintiff was not involved with the murders of the students. Ashley Guillard, through her silence, has admitted that Professor Scofield has not done any of the things that she says she did. Do you see why I've been hinting at this? Do you see why I've been looking forward to doing this one once we got through all the other stuff? Boy, you've got to respond to the discovery requests. Oh, this is good. This is good stuff. This makes me very happy that she admitted to them. She admitted to them. Request 5. Admit that the only basis for your statement that plaintiff had an affair with Kayla Gonsalves is your spiritual research, intuition, and instincts. Admit that that's also the only basis for your statement about the murders. 7. Admit that you have never been to Moscow, Idaho. 8. Admit that you have never been to the state of Idaho. 9. Admit that you are not aware of any physical evidence linking plaintiff to the murders. 10. Admit that you are not aware of any physical evidence showing that plaintiff had an affair with Kayla Gonsalves. 11. Admit that you never said plaintiff communicated with Brian C. Koberger about the murders until after Mr. Koberger was arrested on or about December 30th, 2022. 12. Admit that you never said plaintiff had access to a white Hyundai Elantra until after law enforcement publicly stated they were looking for information about a white Hyundai Elantra in relation to the murders on or about December 7th, 2022. I love that by her silence, she has admitted that her spiritual intuition is just a post hoc justification after the police have already given the information out to the public. Funny how that works, isn't it? 13. Admit that you have never communicated with Jack DeCoeur. I believe that's the person she alleges is the hitman. 14. Admit that you have never communicated with Brian C. Koberger. 15. Admit that you have no written information showing that plaintiff ever met Xana Kernodle. 16. Admit that you have not received any information orally from another human being showing that plaintiff ever met Xana Kernodle. And then 17 and 18 ask the same questions concerning Madison Mogan. 19 and 20 ask the same questions concerning Ethan Chapin. 21 and 22 ask the same questions concerning Jack DeCoeur, and these are asked as separate so that Guillard can't object that these are compound, because technically if a question contains multiple parts, then there are multiple questions, and each part counts against the number you're allowed. 23. Admit that you received and read a cease and desist letter from Stoll Reeves dated November 29th, 2022. 24. Admit that after you received and read that cease and desist letter dated November 29th, 2022, you continued to state publicly that Rebecca Scofield had an affair with Kaylee Gonsalves. 25. Same question except about the murders. 26. Same question about the second cease and desist on December 8th. And then 27 and 28 are the same questions about that second cease and desist. 29. Admit that you are aware that on or about December 27th, 2022, the Moscow Police Department issued a press release related to the murders stating, at this time in the investigation, detectives do not believe the female associate professor and chair of the history department at the University of Idaho suing a TikTok user for defamation is involved in this crime. And 30. Admit that after you became aware of the press release described in request for admission number 29, you continued to state that plaintiff was involved with murders. And that's the date I was looking for, dated June 20th, 2023. Remember, June 20th, 2023 is when that was sent. Looking at the rule, 36, A3, effect of not responding. Okay, that's what I was looking for. A matter is admitted unless within 30 days after being served, the party to whom the request is directed serves on the requesting party a written answer or objection addressed to the matter and signed by the party or. So that's what I'm looking for in Rule 37. it's responded to within 30 days. Within 30 days of June 20th. So if Ashley Guillard doesn't respond by either answering the request for admission or objecting to the requests for admission by July 20th, they're admitted. They're admitted. So let's look back here. What's happened since July 20th? What's happened since July 20th? So we have a minute entry for proceedings on the motion to quash summonses. So that was the court hearing over the Facebook subpoena nonsense. The 27th, we had the motion to quash. Okay, sorry. That was the motion to quash the summonses of the attorneys. So saying, yeah, the attorneys can't be countersued. They're not parties. So that's what happened the day after the requests for admission were due. A week later, there was the motion to quash this Facebook subpoena. A month later, a month and a day later, we had the first motion to dismiss complaint. Our last video. And then the response and reply. So basically, all that has happened with her basically having admitted everything. Isn't that just gorgeous? I love it. So with that, let's jump to the plaintiff's motion for partial summary judgment. Once again, my obligatory moaning about why separate the motion from the memorandum in support. Just do it as one document. This annoys me, but either way. So pursuant to Federal Rule of Civil Procedure 56 and Local Rule 7.1b, plaintiff Rebecca Scofield moves the court for partial summary judgment as to liability on each of her claims. So as to liability, I know I've mentioned this in previous videos, but this is a partial summary judgment. They're saying, judge, rule on these issues. Other issues, we need further litigation or even a trial. So basically, they want partial summary judgment as to liability. They want the judge to say, yeah, Ashley Guillard is liable. And then the only issue is how much is she liable for? So it's, yes, summary judgment. Yes, you defamed Professor Scofield. The only issue is, do you owe her $1? Do you owe her $2 million? Do you owe her a whole hell of a lot more? That should be the only issue going forward once this is ruled on. So this motion for partial summary judgment is supported by the memorandum in support, Professor Scofield's statement of undisputed material facts, the declaration of Wendy J. Olson with exhibits thereto, the declaration of Rebecca Scofield with exhibits thereto, and the pleadings and other documents on file in this action. And that's dated October 10th, 2023. Let's move on to the memorandum in support. So looking at the table of contents, we've got the introduction, background, factual and procedural history, legal standards. We've already discussed the legal standards, at least partially. And then argument. Ms. Guillard's failure to respond to requests for admission conclusively establishes the material facts. The facts conclusively established by Ms. Guillard's admissions demonstrate Professor Scofield's entitled to judgment as a matter of law. So, summary judgment is also called judgment as a matter of law. It's abbreviated for some unknown reason. I think it's because it's Latin, as JNOV. There's another abbreviation similar to JNOV. I just can't remember what it is off the top of my head. That's kind of a more archaic use since the federal rules of civil procedure were standardized. So, but she's entitled to judgment as a matter of law on count 1 because Ms. Guillard communicated information regarding Professor Scofield to others, and those communications were defamatory per se. So that's both elements. She's entitled to judgment as a matter of law on count 2 because she communicated information concerning Professor Scofield to others. And Ms. Guillard's false statements that Professor Scofield maintained a romantic relationship with a student are defamatory as a matter of law. So it's per se defamatory. Both because Ms. Guillard's statements ascribe conduct to Professor Scofield that is incompatible with the proper conduct of a professor, and they impute serious sexual misconduct to Professor Scofield. So just judging by the exhibits, this is going to be about, Ashley Guillard is alleging that Professor Scofield violated her rules of employment at the University of Idaho. They, some of the exhibits that we're not going to bother looking at because they're boring are the employee code of conduct concerning relationships and students and disclosure of relationships and all that stuff. So and then we have the table of authorities. It's almost like this is written by a professional. And finally, 5 pages in, we're to the introduction. Plaintiff Rebecca Scofield respectfully requests that the court enter summary judgment on both her claims against defendant Ashley Guillard. As a matter of law, and as a consequence of her failure to engage in this litigation as required by the federal rules of civil procedure, Ms. Guillard has admitted to defaming Professor Scofield. Ms. Guillard's admissions establish beyond dispute that Ms. Guillard is liable for her defamation of Professor Scofield. Accordingly, all that remains is for a jury to determine the extent of Professor Scofield's damages. So that's basically what I already said. It's the only issue remaining is for the jury to determine how much damage. Background, factual history. In November 2022, 4 students at the University of Idaho were murdered at a home near campus. And we have footnote 1, to respect the privacy of the victims, this memorandum uses their initials. And I refer to them as the students or the victims. Ms. Guillard, a resident of Texas, took this tragedy as an opportunity to post sensationalist content online to attract clicks and make money. According to Ms. Guillard, she used her spiritual practice, psychic abilities, and metaphysical tools, including tarot cards, to post over 100 TikTok videos of her supposed findings, in quotation marks, concerning the murders near the university. Ms. Guillard's purported findings, still in quotation marks, which she posted on the social media website TikTok, went like this. Professor Scofield had a same-sex affair with one of the victims and then planned, initiated, ordered, and executed the murder of the 4 University of Idaho students. Ms. Guillard has admitted that she made these sensational statements, and she has admitted that these statements are false. See generally Statement of Undisputed Material Facts in support of motion for summary judgment. And for that, it's paragraphs 11 through 19 and 24 through 30. We'll take a look at the Statement of Undisputed Material Facts in a little bit. Ms. Guillard has also admitted that her false statements are based on nothing more than her spiritual research, intuition, and instincts, and that she has no written information or oral information from another human being that support her false statements. In a good faith attempt to resolve this matter without litigation and to avoid drawing further attention to Ms. Guillard's utterly baseless statements, Professor Scofield sent cease and desist letters to Ms. Guillard on November 28, 2022 and December 8, 2022. In fact, if Ms. Guillard had responded positively to those cease and desist letters, this never would have been brought to my attention. I never would have made a single video on this. So, yeah. Ms. Guillard received these letters and promptly disregarded them, instead choosing to continue spreading false information for her own pecuniary gain. Given Ms. Guillard's willful disregard for the cease and desist letters, Professor Scofield filed her complaint, asserting 2 defamation claims, one relating to Ms. Guillard's false statements that Professor Scofield was involved in the murders, another relating to Ms. Guillard's false statements that Professor Scofield was romantically involved with one of the victims. The factual history of this matter is set forth in more detail in the concurrently filed Statement of Facts, the Statement of Unopposed Facts which is incorporated herein by reference as if set forth in full. Procedural history. Professor Scofield filed her 2-count complaint on December 21st, 2022. Ms. Guillard failed to answer or otherwise respond to the complaint within the time called for under the Federal Rules of Civil Procedure, and, pursuant to Rule 55A, Professor Scofield filed a motion for clerk's entry of default on January 19th, 2023. A clerk's entry of default was filed on January 27th. After failing to respond to the complaint and being found in default, Ms. Guillard filed a motion for relief from judgment and an answer, affirmative defenses, and counterclaims on February 16th. Professor Scofield responded by filing a motion for default judgment on February 17th and filed a motion to strike Ms. Guillard's answer, affirmative defenses, and counterclaims on February 27th. The reason she's laying out the procedural history like this so thoroughly, because, does the procedural history really matter for a summary judgment motion? No. We only care about undisputed, facts. Facts that both sides agree on. That's so basically we care about the allegations made, and if the factual allegations are opposed. We don't care when things were filed, except Professor Scofield is trying to hammer home, look, Ashley Guillard has been late all the time on everything. And the court hasn't bothered to actually give her consequences for being late, for not following the rules. Even though, as I'm sure we're about to see, when she asked for the court to set aside the default, she said, I promise I'll follow the rules. I'll meet all the deadlines. And she hasn't. But so they don't want the court to say, she was served the request for admissions June 20th. They were due July 20th. This motion was filed October 11th. So July, August, September, October, that's 2.5, 2 2/3 months after they were due that they finally filed this motion. So she had 30 days to respond. She had 2 2/3 months, 2 months and 20 days in which to file a request to, give them late, to file late admissions or denials. But she didn't even bother to do that. That's why they're laying this out, the procedural history, in such detail, because it doesn't matter for the purposes of this summary judgment motion, but it could matter saying, Judge, we're holding your feet to the fire. You can't keep letting her slide. She is pro se, but pro se are still held to the rules, and they're held strictly to the rules of civil procedure. You need to start doing that. You need to start holding her to the rules. There are consequences if she doesn't follow the rules. And this is a mighty big consequence. On October 26th, the court issued a memorandum decision and order granting Ms. Guillard's motion to set aside entry of default, granting Professor Scofield's motion to strike, and denying as moot Professor Scofield's motion for default judgment. In granting Ms. Guillard's motion, the court reasoned that her failure to timely respond to plaintiff's complaint was most likely an unintentional oversight caused by self-serving carelessness, and that although the court did not condone it, such failure did not amount to bad faith with an intention to take advantage of the opposing party, interfere with judicial decision-making, or otherwise manipulate the legal process. The court also found that Ms. Guillard satisfied the low meritorious defense hurdle and that setting aside the entry of default would not prejudice Professor Scofield. And we have footnote 2. When the court set aside Ms. Guillard's default, it also wrote, defendant represents that, going forward, she will prioritize court rules, orders, and actions, and file timely actions. Told you that statement would come up. The court intends to keep defendant to her word. Ms. Guillard has not kept her word. She represented to the court on February 16th that she would prioritize submitting filings timely, but since then, she failed to file timely responses to, number 1, plaintiff's motion for default judgment, 2, plaintiff's motion to strike answer, 3, plaintiff's motion for sanctions, and 4, plaintiff's motion to quash. And here, she has completely failed to respond to plaintiff's discovery requests. Like I said, not only was she late, that they didn't file this on the day after she failed to respond. They waited 2 months and 20 more days. So they're not saying, hey, she was late. She hasn't even responded. She was given 30 days. She took 110 days and didn't respond. You cannot let her slide on this. You can't. And it's just this blows my mind. It absolutely blows my mind. Remember, a couple videos ago, discussing the Facebook subpoena. In her reply, Ashley Guillard said, I didn't bother to request Professor Scofield's Facebook data from her. I went straight to a subpoena, even though that might not be the proper way to go about this. I didn't bother to request it from Professor Scofield through the rules of evidence because she wouldn't have given it to me anyway. She would have, brushed it off. But you didn't respond to her request for discovery. Not just the request for admissions, the request for discovery. You do not have clean hands here. And may I remind you, the motion to quash the subpoena was a week after these were due. A week after. I mean, this is just nuts. And I'm curious. July 13th. July 13th is when she sent the subpoena to Facebook. So she actually had 7 more days to respond to Professor Scofield's discovery requests. But she never did. She still hasn't. It's she has not just unclean hands, she has filthy hands. Ms. Guillard refiled her answer, affirmative defenses and counterclaims on May 16th. And on June 6th, Professor Scofield filed a motion to dismiss Ms. Guillard's counterclaims. The court heard argument on Professor Scofield's motion to dismiss on July 21st, the day after these responses were due, and issued a memorandum decision and order dismissing Ms. Guillard's counterclaims on August 8th. On August 22nd, Ms. Guillard filed a motion to set aside the court's memorandum decision and order concerning the dismissal of her counterclaims, which remains pending. Legal standards. Rule 56A, remember we looked at Rule 56, specifically 56A, provides that a party may move for summary judgment, identifying each claim or defense, or the part of each claim or defense on which summary judgment is sought. And they added emphasis, or the part of each claim or defense. So the emphasized portion of Rule 56A permits parties, like Professor Scofield here, to move for summary judgment on liability, so partial summary judgment, while leaving the amount of damages for trial. CEG U.S. SEC versus Cutting, District of Idaho 2022, which granted a motion for summary judgment on liability. Now, we have another very famous case, and it might have been either 22 or 23. It's the Alex Jones suit where he was sued by the Sandy Hook parents. He defaulted. So that wasn't actually a partial summary judgment, but it was still bifurcated in that he defaulted as to liability, and the trial was held as to the amount of damages. So it's not a one-to-one comparison here. But it's also not apples to oranges. It's like Golden Delicious to Fuji apple. The standard for summary judgment is familiar. Summary judgment is appropriate when, viewing the evidence in the light most favorable to the non-moving party, there is no genuine dispute as to any material fact. And that's Zetvik versus County of Yolo, 9th Circuit, 2017. And I did forget to put that part. It's in the evidence in the light most favorable to the non-moving party. So we look at the evidence granting the benefit of the doubt, basically, to the non-moving party, to Ashley Guillard. But if we look at the evidence in the light most favorable to her, and there is still no genuine dispute as to any material fact, then Professor Scofield wins. So, and then also Federal Rule of Civil Procedure 56A, the court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. So it can't just be there's no dispute as to material fact, but we're making up a cause of action. You still have to be entitled to judgment as a matter of law. There has to be some cause of action for you to win on. The facts have to apply to a cause of action. So where the record taken as a whole could not lead the rational trier of fact to find for the non-moving party, there is no genuine issue for trial, and summary judgment is appropriate. And that's, again, citing Zetvik, which itself quotes Ricci versus De Stefano, however you pronounce it, Supreme Court, 2009. The district court must not only properly consider the record on summary judgment, but must consider that record in light of the governing law. And that's the same quote, which quotes Anderson versus Liberty Lobby, Inc., Supreme Court, 1986. So now to the argument. First, Ms. Guillard's failure to respond to requests for admission conclusively establishes the material facts. Federal Rule of Civil Procedure 36A1, remember we looked at Rule 36, provides that a party may serve on any other party a written request to admit the truth of any matters within the scope of Rule 26B1 relating to A. Facts, the application of law to fact or opinions about either, and B. the genuineness of any described documents. So basically they could say, admit or deny that this TikTok is legitimately you. It's genuine because it says any described documents, but TikTok videos, those will count. Admit this is genuine. Admit you did this. Following service of requests for admission under Rule 36A, the responding party has 30 days to admit, deny, or object to such requests. That's Rule 36A3. If the responding party fails to timely respond, the matter is deemed admitted. We looked at that. That's a big deal. A matter admitted under this rule is conclusively established unless the court, on motion, permits the admission to be withdrawn or amended. There has been no such motion. In the 2 months and 20 days between her failure to respond and the date of this partial summary judgment motion, Ashley Guillard has not done a motion. She has not moved the court to withdraw the admissions. So as of now, they're conclusively admitted. And like I said, this was filed October 11th, or October 10th, sorry. She filed her opposition on Halloween. She may be trying to piggyback. Like I said, I haven't read her opposition. I've only glanced at a brief little snippet that made me real mad. But you can't piggyback. You've got to bring your own motion. So as of now, even if she's tried to piggyback in her opposition motion, she hasn't requested relief. Not that she should be granted relief. The court needs to hold her accountable for once for failure to follow the rules. So, Professor Scofield served Ms. Guillard with discovery requests, including requests for admission pursuant to Rule 36 on June 20th. Accordingly, Ms. Guillard's responses to those requests for admission were due no later than July 20th. To date, Ms. Guillard has not responded to Professor Scofield's requests. Therefore, she is deemed to have admitted the truth of each fact identified in Professor Scofield's requests for admission. Professor Scofield has waited patiently for Ms. Guillard to respond, but 2.5 months after her responses to Professor Scofield's requests for admission were due, Ms. Guillard has not responded. I mean, they were even generous. They didn't count the 5 days after the 2.5 month date after they were due. Of course, lawyer math, 20 out of 30. Yeah, that's close enough to half. The effect of the admission under Rule 36, whether an affirmative admission or a deemed admission due to a failure to respond, is clear. A matter admitted under this rule is conclusively established. Emphasis added. I added emphasis too because they added emphasis. Accordingly, concerning Professor Scofield's first claim for relief relating to Ms. Guillard's false statements regarding the murders of the students, the following facts have been conclusively established by Ms. Guillard's admissions and other evidence. Ms. Guillard stated publicly that Professor Scofield was involved in the murders. Professor Scofield was not involved in the murders. The only basis for Ms. Guillard's public statements that Professor Scofield was involved in the murders is Ms. Guillard's spiritual research, intuition, and instincts. Ms. Guillard is not aware of any physical evidence linking Professor Scofield to the murders. Ms. Guillard has no written information and has not received any information orally from another human being showing that Professor Scofield ever met any of the students. They listed each of them as separate, undisputed facts, but I'm lazy. Ms. Guillard knew that the Moscow Police Department issued a press release on December 27th, 2022, stating that it did not believe that the female associate professor and chair of the history department who is suing a TikTok user for defamation is involved in this crime. And concerning Professor Scofield's second claim for relief, the following material facts have been conclusively established. Ms. Guillard publicly stated that Professor Scofield had an affair with a student. Professor Scofield did not have an affair with the student and murder victim. The only basis for Ms. Guillard's statement that Professor Scofield had an affair with the student was Ms. Guillard's spiritual research, intuition, and instincts. And you'll notice these are all cited as statement of facts at paragraph 31. The next statement of facts at paragraph 32. So Ms. Guillard is not aware of any physical evidence showing that Professor Scofield had an affair with the student. Next up, the facts conclusively established by Ms. Guillard's admissions demonstrate Professor Scofield's entitlement to judgment as a matter of law. In a defamation action, a plaintiff must prove that the defendant, 1, communicated information concerning the plaintiff to others, and 2, that the information was defamatory, and 3, that the plaintiff was damaged because of the communication. That's Clark versus Spokesman Review, Idaho Supreme Court, 2007. Now, number 3, element 3, doesn't matter here because this is defamation per se. This lays out the 3 elements of basic defamation. So, a defamatory statement is one that tends to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, or ridicule, or by adversely affecting the person's business. That's Elliott versus Murdoch, also the Idaho Supreme Court in 2016. Moreover, the Idaho Supreme Court has recently held that a statement is defamatory per se if it imputes to another conduct constituting a criminal offense, if the offense that is imputed is of a type which, if committed in the place of publication, would be A, punishable by imprisonment in a state or federal institution, so a felony, or B, regarded by public opinion as involving moral turpitude. So that could involve crimes of moral turpitude, such as fraud, but also moral turpitude, that would be, unchaste behavior, being a whore, being, I'm using archaic language because moral turpitude, I think, is archaic, but, saying someone is a whore, that's implying moral turpitude. Saying someone has had an affair, that's implying moral turpitude. Saying someone is a thief, that's implying moral turpitude. And that was Sirkey versus Sirkey, Idaho Supreme Court 2020, which quotes the Restatement Second of Torts, Section 571. Under this test, the proper focus of a defamation per se inquiry is the nature of the conduct imputed. And if criminal conduct is imputed and that conduct amounts to either a crime punishable by imprisonment or a crime of moral turpitude, the allegedly defamatory remarks are actionable as defamation per se. That's Sirkey versus Sirkey still. Similarly, a statement is defamatory per se if it ascribes to another conduct, characteristics, or a condition that would adversely affect her fitness for the proper conduct of her lawful business, trade, or profession. Second Restatement of Torts, Section 573, or imputes serious sexual misconduct to another. So, saying she had an affair. And especially saying she had a relationship with the student. That would be serious sexual misconduct. C, Yoakum versus Hartford Fire Insurance Company, Idaho Supreme Court 1996, which recognized that statements are defamatory per se if they impute to the plaintiff either a criminal offense, a loathsome disease, so saying they have AIDS, saying they have the clap, saying that, saying they have cancer. Cancer, while a terrible disease, probably isn't a loathsome disease because, it's generally not going to imply that you've done something, that your bad conduct hasn't caused cancer. Of course, anymore, it might become the case that, smoking is frowned on by a large section of society. So it might be to the point where, suggesting someone has lung cancer, that might quote as a loathsome disease for the purposes of defamation. I I don't think it would, but it might. I'd make that argument with a straight face. So a loathsome disease, a matter incompatible with his trade. So, a professor, uh, a relationship with a student by a professor is a matter incompatible with that professor's trade. Being a professor is the trade. Business or profession, or so with their trade, business, profession, or office. So profession here, not trade. Or serious sexual misconduct. And that's citing the Second Restatement of Torts, sections 570 through 574. Statements that rise to the level of defamation per se do not require proving special damages. That's, once again, Cirque versus Cirque. Whether a statement is defamatory per se is a question of law for the court. So that's a question for the court to decide, a question of law, not a question of fact. So the court gets to decide, yes, this type of statement is defamatory per se as opposed to regular defamation. So the court gets to decide pre-trial whether you have to prove damages, at least to win. So because the court decides that the allegations made in the complaint are defamation per se, if this went to trial, the jury instructions would basically be for the elements of defamation per se. Admissions made under Federal Rule of Civil Procedure Rule 36, even default admissions, which we have here, can serve as the factual predicate for summary judgment. That's United States versus Kasabowski, 7th Circuit, 1987. So there you go. These are the undisputed facts, because even default admissions can serve as the undisputed facts that you base the summary judgment on, the factual predicate for summary judgment. Indeed, because evidence inconsistent with a Rule 36 admission is properly excluded, summary judgment may be granted solely based on Rule 36 admissions, even where other evidence might contradict those admissions. That's citing 999 versus CIT Corp., 9th Circuit, 1985, with footnote 3. To be clear, there is no evidence contradicting Ms. Guillard's admissions here. But even if there were evidence contradicting Ms. Guillard's admissions, we'd still be able to get to summary judgment because we've got the facts for summary judgment. So I don't know. I'm not creative enough to think of, contradictory evidence that would be relevant, but not enough to to prevent summary judgment. Luckily, I don't have to because, there is no such evidence. So, Professor Scofield is entitled to judgment as a matter of law on count one. That's the murders. Count one concerns Ms. Guillard's false and defamatory statements that Professor Scofield was involved in the murders of the 4 students. In particular, beginning on or about November 24th, 2022, Ms. Guillard posted videos on TikTok in which she falsely stated that Professor Scofield was responsible for, ordered, or was otherwise involved in the 4 students' deaths. Now, I'm curious, for those of you who have seen all of Ashley Guillard's TikToks, because they're gone. At least they're not on TikTok, not on her TikTok. And I haven't watched them other than, compilations by Markey and Atosi and a few others. But did she do is the tarot reading on video? Or did she just say on video that she did a tarot reading? Because I'm just curious if there's I don't put any stock in her tarot readings. I think it's a bunch of bunk. Although this video is taking too long, so I'm not going to do a non-Scofield versus Guillard video to put out this afternoon. But you're going to see that I actually am a psychic. Because, I was thinking 2 days ago, I was trying to remember the name of Eddie Alexander Banks. And then Van Bellion did a video the next day on Eddie Alexander Banks, sovereign citizen. So clearly I am a psychic, but I still believe her tarot reading was a bunch of bunk. But I'm curious if there's video evidence. Could if I were Ashley Guillard, I took it to trial, I'd try to get the video of the tarot reading before the jury, and maybe even get a well-regarded psychic to review it as an expert witness and say, well, yeah, this tarot reading makes sense. It it clearly, whether it's right or not, it pointed in that direction. She read the cards right. She ascribed the proper meaning to the cards. There is no actual magic power to it, I don't believe, but there should be kind of a generally accepted interpretation of the cards within the industry. And so it's like she'd have a better defense if she had experts on the interpretation of tarot cards saying, well, yeah, that this is what she should have read from it. Because then, she's got a better argument. Well, I wasn't reckless. This wasn't a reckless disregard for the truth because, look, my expert said I read the cards right. That doesn't mean they were right, but I read the cards right. So I'm curious if there is video of the tarot reading. Tangent over, let's go. In particular, beginning on or about November 24th, Ms. Guillard posted videos on TikTok in which she falsely stated that Professor Scofield was responsible for, ordered, or was otherwise involved in the 4 students' deaths. Ms. Guillard's publishing of these videos on TikTok constitutes a communication as a matter of law. And because Ms. Guillard's statements impute criminal conduct for which the punishment is greater than 1 year imprisonment, so a felony, the statements are defamatory per se. Accordingly, Professor Scofield is entitled to summary judgment on count 1. Ms. Guillard communicated information regarding Professor Scofield to others. So we have a section for each element of the claim. This is the communication element. Ms. Guillard has admitted that she publicly stated that Professor Scofield was involved with the murders of the 4 students. And that's clearly an undisputed fact, because I mean, yeah, it's deemed admitted because she failed to respond for this request for admission, but she freely admits this part. She's like, yeah, I did all those tips and I stand by them. So this admission conclusively establishes that Ms. Guillard communicated information concerning the plaintiff to others. That's citing Serkey once again. And Federal Rule of Civil Procedure 36A3. While few cases dwell on what it means to communicate information concerning the plaintiff to others, Serkey, there is no doubt that Ms. Guillard's posting of the videos on TikTok satisfies this element. The element of publication or communication requires the defamatory statement be communicated to a person other than the person defamed. And that's citing Irish versus Hall, Idaho Supreme Court, 2018. So if Ashley Guillard had met Professor Scofield at a bar and said, "You're a murdering cow," that's not defamation. At least, if Professor Scofield is the only one that hears it, it might be defamation, even though it's communicated to Professor Scofield if they are in a crowded bar and, lots of other people hear it, because by telling Professor Scofield, "You're a murdering cow," she's communicated that to others in the bar. So, but if she picked up her phone and called Professor Scofield and said, "You're a murdering cow," well, that wouldn't be communicating to others. So the publishing element wouldn't be satisfied. Let's say there was a wiretap on her phone, or there was a psychic, observing through her crystal ball. That wouldn't count, because that's unforeseeable. You can't hold her to that. And Irish versus Hall was abrogated on other grounds by Serkey, but something that, basically, even if one case is overturned by another, it could still be valid case law, just not for the purposes of whatever was overturned, whatever overturned it. And I'm real glad my phone decided to restart, update and restart and buzz as that's annoying. So, yeah. Okay. In both print and internet publishing, information is generally considered published when it is made available to the public. And that's, I'm assuming Irish versus Hall, maybe Serkey. But either way, it's quoting OHA versus U.S. Army Corps of Engineers, Ninth Circuit, 2006. Thus, once information has been published on a website or print media, there is no further act required by the publisher to make the information available to the public. So it doesn't require me clicking on the TikTok video to watch it. Her posting it on TikTok, that's enough. No other steps required. Even absent Ms. Guillard's admissions, there can be no dispute that she communicated information concerning Professor Scofield to others. Beginning on or about November 24th, 2022, Ms. Guillard posted TikTok videos to her account in which she falsely stated, both directly and indirectly, that Professor Scofield was responsible for, involved in, and ordered the murder of the 4 students. Over the following 4 days, Ms. Guillard posted additional TikToks in which she continued to falsely assert that Professor Scofield ordered and planned the murders of the 4 students. These TikToks put more details to Ms. Guillard's false theory, as Ms. Guillard claimed that Professor Scofield and a different student at the University of Idaho, J.D., footnote 4, as with plaintiff's complaint, this memorandum uses the initials J.D. to protect the individual's privacy and not perpetuate Ms. Guillard's false and defamatory statements. And we read his name in the request for admission, and we say we don't believe he had anything to do with the murders or with Professor Scofield or anything, and he's another unfortunate victim of Ashley Guillard. He should probably sue her too. So the TikToks put more details to the false theory, as she claimed that Professor Scofield and JD together planned the murders. In one of her November 28th TikToks, Ms. Guillard included text stating, "I don't care what y'all say. JD and Professor Scofield killed the students. Rebecca was the one to initiate the plan and hired JD." In all, Ms. Guillard herself estimates that she posted over 100 TikTok videos of her supposed findings, in which she communicated her baseless theory that Professor Scofield was in a relationship with KG that broke up, and she initiated the murders, planned the murders, and hired JD to help carry the plan out. And Ms. Guillard has continued to make defamatory statements even after Professor Scofield's November 28th and December 8th, 2022 cease and desist letters. Since December 1st, 2022, Ms. Guillard has posted additional TikToks stating, among other things, that Rebecca Scofield is going to prison for the murder of the 4 University of Idaho students, whether you like it or not. And I'm not worried about Rebecca Scofield suing me because she will be using her resources to fight 4 murder cases. And she ordered the murders of the students. Moreover, Ms. Guillard's TikToks were, in fact, viewed by thousands, if not millions, of people. Some of her TikToks defaming Professor Scofield had thousands of likes, indicating that a third party had viewed the video and liked it. Ms. Guillard's admissions and this evidence establishes beyond dispute that she communicated information about Professor Scofield to others. That's citing Irish, which says, in both print and internet publishing, information is generally considered published when it is made available to the public, not when the public views it. Next element, Ms. Guillard's communications were defamatory per se. Ms. Guillard's statements unambiguously impute to Professor Scofield conduct constituting a criminal offense that would be punishable by imprisonment in a state or federal institution. That's citing Sirki once again. Ms. Guillard variously asserted falsely that Professor Scofield killed the students, was the one to initiate the plan and hired the supposed hitman, ordered the murder of the 4 University of Idaho students, and broadly claimed that Professor Scofield was involved in the killings. Indeed, Ms. Guillard has admitted that she stated publicly that Rebecca Scofield was involved with the murders. Ms. Guillard's admissions and the uncontroverted evidence in this case conclusively establish that Ms. Guillard's statements impute to Professor Scofield conduct constituting a criminal offense that would be punishable by imprisonment in a state or federal institution. And footnote 5, CEG, Idaho Code Annotated, sections 18-4001, murder, defined, 18404, punishment for murder, 18406, 4006, manslaughter, defined, 18-4007, punishment for manslaughter, 18-1701, criminal conspiracy, defined, because she alleged a criminal conspiracy to commit murder. 18-204, principles, defined. That would be the principles in the conspiracy. 18-205, accessories, defined. 18-206, punishment of accessories. 18-2001, solicitations, defined. So solicitation of murder. And 18-204, 2004, punishment for solicitation. So I actually find this fairly amusing, that murder defined 18-4001. Because remember, in Ashley Guillard's counterclaims, she sued under 18 USC section 4001, the definition of defamation for the purposes of enforcing foreign defamation judgments in federal court. So she sued under section 4001, which was not a cause of action. They got 18. And it's even section 18-4001. 18-4001, as opposed to 18 USC section 4001. That really amuses me. That really amuses me. And that last thing was also quoting Sirki. Accordingly, Ms. Guillard's false statements concerning Professor Scofield's purported involvement are defamatory per se as a matter of law. And, per se basically is as a matter of law, so that's kind of redundant. And this court should determine, as a matter of law, that Ms. Guillard is liable to Professor Scofield on count 1. And that's citing Sirki again, and Federal Rule of Civil Procedure 56A, permitting summary judgment on a part of a claim like liability. And cutting, again, where it granted a motion for summary judgment on liability, which is part of a claim. So, next up, Professor Scofield is entitled to judgment as a matter of law on count 2. As with count 1, Ms. Guillard's admissions establish as a matter of law that Professor Scofield is entitled to judgment on count 2. Ms. Guillard admitted to posting TikToks containing assertions that Professor Scofield was in a romantic relationship with one of the victims, KG, admitted that those assertions were false, and admitted she has no evidence to support her false assertions. Ms. Guillard communicated information concerning Professor Scofield to others. For the same reasons as discussed above in reference to count 1, Ms. Guillard's TikToks that contained false assertions that Professor Scofield had a romantic relationship with KG constitute communications concerning Professor Scofield. As a matter of law, therefore, Ms. Guillard has admitted to the first element of the defamation claim asserted in count 1. That's citing Irish once again. The next element, Ms. Guillard's false statements that Professor Scofield maintained a romantic relationship with a student are defamatory as a matter of law. A defamatory statement is one that tends to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, or ridicule, or by adversely affecting the person's business. That's Cirque. In addition to statements imputing criminal conduct, the Idaho Supreme Court has recognized 3 other categories of statement that are defamatory per se and therefore do not require proof of special damages. That's citing Barlow versus International Harvester Company, Idaho Supreme Court, 1974, which says defamatory utterances regarding an individual are slanderous per se if they fall into one of the 4 categories. And Barlow was abrogated on other grounds by Cirque. 2 of these other categories are relevant here. 1, utterances which ascribe to another conduct, characteristics, or a condition incompatible with the proper conduct of his lawful business, trade, or profession. And that's quoting Restatement of Torts, Section 573. See also the second Restatement of Torts, Section 573. And 2, statements that impute serious sexual misconduct to another. And that's Second Restatement of Torts, Section 574. And Yoakum from the Idaho Supreme Court, which recognized that statements which impute to the plaintiff serious sexual misconduct are defamatory per se. So the Restatement of Torts, and in this case, the second Restatement of Torts, those are basically, they're persuasive. That they're not actual law books. They're not code. And I mean, if they were code, then these torts wouldn't be common law torts. They'd be statutory torts. So basically, what you do is the restatement of torts, or there's also the restatement of contracts, the restatement of, whatever other subject you want to talk about. You get a bunch of eggheads together, usually law professors, lawyers, judges, whatever, and they get together and say, these are the general, these are the elements that constitute this tort. These are what we believe should constitute this tort. And so they're going to have the section, but they're also going to have a whole list of footnotes that really go into detail. But that's not law. And so you can quote the Restatement of Torts as persuasive and say, Judge, we think Idaho has not adopted Section 573 of the Restatement of Torts. We invite the court to do so at this time. And put forth a persuasive argument, and the court might or might not. And funny enough, let's relate this to sovereign citizens. The Uniform Commercial Code that sovereign citizens say is mandatory law is not law at all. The Uniform Commercial Code is the commercial equivalent of the Restatement of Torts. It's a bunch of eggheads got together and said, this is what we think should be commercial law. And the states either adopted it or didn't. So most states have. There's some articles in it that certain states have not adopted it at all. I'm looking at you, Louisiana. But so the Uniform Commercial Code doesn't apply in Utah. We have the Utah Commercial Code contained within the Utah Code. It's virtually identical to the Uniform Commercial Code, but it's the Utah Commercial Code. So I just find it so funny when sovereign citizens say the Uniform Commercial Code is mandatory law, the federal government mandates that, and it's, traffic laws don't apply to me because of the Uniform Commercial Code, because I'm not subject to codes and statutes and codes, except for this statute and code, the Uniform Commercial Code, even though it's a code and it's not you. Yeah. So either way, the purpose of that tangent was, we have them stating or citing the restatement, second restatement of torts, section 574, but then they cite Yoakum to say, look, Idaho courts have already adopted section 574 as binding law in the state of Idaho. It's good law. It's not just persuasive like the second restatement of torts is. This is good law in Idaho. So Ms. Guillard's false statements underlying count 2 are defamatory per se under both of these categories. So both for saying serious sexual misconduct and for nonsense that could put her job in jeopardy. So incompatible with the proper conduct of a professor. That's a better way to put it than nonsense that'll put her job in jeopardy. Means the same thing though. So Ms. Guillard's statements ascribe conduct to Professor Scofield that is incompatible with the proper conduct of a professor. First, it cannot be genuinely disputed that a romantic or sexual relationship between a professor and student at that professor's university is conduct incompatible with the proper conduct of the professor's lawful business, trade, or profession. That's citing Barlow again. Indeed, the incompatibility of a professor-student romantic relationship is enshrined in the University of Idaho's policy concerning consensual romantic or sexual relationships. So I mentioned that earlier. Those are a couple of the exhibits. We're not going to look at them, but that's what they were included for. It's saying, hey, look, these false statements could put her job in jeopardy if the university believed them, because she's, Ashley Guillard is implying that Professor Scofield violated these university policies, these employment policies, which we're posting right here. And these are fireable offenses that could seriously cause damage to Professor Scofield. So that policy states in no uncertain terms that it is the policy of the University of Idaho that no employee shall enter into or continue a romantic or sexual relationship with a student or employee over whom she or he exercises academic, administrative, supervisory, evaluative, counseling, or other authority. Moreover, the University of Idaho maintains a policy condemning sexual harassment, which explicitly includes within the definition of sexual harassment behavior that overtly or covertly uses the power inherent in the status of a professor, teacher, or other officer to affect a student's educational experience or career opportunities. Should a professor at the University of Idaho be found to have violated either of these policies, the professor is subject to discipline, including dismissal. Tell me again, Ashley, how you didn't cause any damages to Professor Scofield. The University of Idaho has implemented these policies for a good reason. A romantic or sexual relationship of the kind forbidden by the policy inevitably raises concerns for objectivity, fairness, and exploitation because they have the potential for abuse and damaging consequences. The imbalance of power creates unacceptable risks of exploitation, favoritism. So it's not only negative impacts for a student, it could be negative impacts for their classmates if a student has a relationship with a professor, because they may exhibit favoritism towards that student. And when I did my undergraduate, well, I mean law school too, but the my bachelor's degree is in finance, and the business school at the University of Utah, at least when I went, they had a brutal, absolutely brutal mandatory curve. I'm talking like for freshman level classes, it was like a 2.8 overall class GPA. Mandatory. That's not conducive to applying to law school, I'll tell you. I was considerably higher than that, but when you're competing with psychology majors or communications majors where a generally smart student should have a high GPA, there's a reason why finance isn't generally, at least not at the University of Utah, it's not considered a pre-law major. So, and then the law school also has a recommended curve, which is considerably higher than 2.8, but it wasn't mandatory, but the professors had to generally have a good reason to go over the curve. So, yeah. So, but that goes to show, if the class curve is set by the university at a 2.8 GPA, that's what, a B minus, and the professor is in a relationship with a average student, so they should get a B minus in the class as thoroughly average, and they get an A. That hurts the other students, because in order to make up for that A, they either have to give fewer A's to other students, or they have to, they've got to find some way to get the class average down. That is actual harm to other students. So makes sense that they have this policy. So favoritism, harassment, and bias, both actual and perceived. So you don't even want the other students to say, hey, look, so-and-so is, sleeping with the professor. They've had an advantage. That could only be a perceived favoritism, but you want to avoid that. But so, and that thereby impairs the integrity of the professional relationship and the trust on which it depends. And the University of Idaho is not alone in adopting such policies prohibiting romantic relationships between professors and students. So why does that matter? She's employed at the University of Idaho. It's because if the University of Idaho believed Ashley Guillard's allegations and fired Professor Scofield or denied her tenure or whatever, other universities have the same policy. So if they fired her for having a romantic relationship with a student, she's not getting hired by another university. Her career in academia is over. So it matters that other universities have such policies. A 2014 study found that 84% of the American universities surveyed had some prohibitions on professor-student relationships. And that's from Amia Srinivasan, What's Wrong with Sex Between Professors and Students? It's Not What You Think. New York Times, September 2021. Opinion, Me Too, teachers, students, consent, within the URL. These policies, including the University of Idaho's, indisputably demonstrate that romantic or sexual relationships between professors and students at the same university are incompatible with the proper conduct of the professor's lawful business, trade, or profession. That's citing Barlow. Accordingly, because Ms. Guillard has admitted to making such statements and admitted that they were false, Ms. Guillard has admitted that these statements too were defamatory per se. But even if the court doesn't agree with that, Ms. Guillard's statements impute serious sexual misconduct to Professor Scofield. So remember, we've discussed alternative pleading multiple times. This is alternative pleading. It's, this is defamation because of this, but it's also defamation because of this. So you can find for me because of A or B, or A and B. Doesn't matter as long as you find for me. So Ms. Guillard's false assertions that Professor Scofield was involved in an inappropriate romantic relationship with KG are also defamatory per se because they impute serious sexual misconduct to Professor Scofield. That's the Second Restatement of Torts, Section 574, and Yoakum from the Idaho Supreme Court. This category of defamation per se applies to a statement charging a woman with general charges of unchaste conduct. Second Restatement of Torts, Section 574, Comment B. Remember, I mentioned in the Restatement of Torts, they have the sections, of the restatement, and then they have the comments, the footnotes that can that's really where you get the good information in the restatements. Undoubtedly, Ms. Guillard's admittedly false statements that Professor Scofield was romantically involved with a student constitute charges of unchaste conduct. Moreover, Ms. Guillard's false statements are particularly serious here, where Professor Scofield is subject to the University of Idaho's policies concerning sexual harassment and romantic relationships between professors and students. As noted above, these policies would subject Professor Scofield to discipline, including termination of her employment had she been engaged in such misconduct. Indeed, Ms. Guillard well knew that she was asserting Professor Scofield had engaged in serious misconduct in violation of university policy. She showed one of the policies in one of her TikTok videos. The evidence is undisputed, however, that Professor Scofield was not involved in any misconduct, and that Ms. Guillard's statements to the contrary in her TikToks were false. I mean, not only that, not only did she know that she was so going back, Indeed, Ms. Guillard well knew that she was asserting Professor Scofield had engaged in serious misconduct in violation of university policy. She showed one of the policies in her TikToks. Not only that, she alleges that Professor Scofield murdered 4 people to avoid detection for this violation. So, yeah. At bottom, maybe in a section discussing serious sexual misconduct, we shouldn't start sentences with, at bottom, just a thought. At bottom, Ms. Guillard has admitted to falsely stating that Professor Scofield was romantically involved with a student at the University of Idaho. These false statements ascribe to Professor Scofield conduct incompatible with the proper conduct of a professor and impute serious sexual misconduct to Professor Scofield, as expressly noted in the University of Idaho's policies governing romantic or sexual relationships between professors and students. Accordingly, Ms. Guillard's false statements on this front are defamatory per se as a matter of law, and the court should determine as a matter of law that Ms. Guillard is liable to Professor Scofield on count 2. Conclusion. For the reasons stated herein, Professor Scofield respectfully requests that the court grant plaintiff's motion for summary judgment and hold Ms. Guillard liable for her defamatory statements as a matter of law. The evidence conclusively establishes that Ms. Guillard's statements that the statements defamed Professor Scofield. All that remains is for a jury to determine the amount of Professor Scofield's damages. And that was submitted October 10th, 2023 by Wendy Olson, attorney for plaintiff. So next, we have the plaintiff's statement of undisputed material facts. So this is what they were citing to in that motion, and yeah. So, pursuant to Federal Rule of Civil Procedure 56 and Local Rule 7.1b, Plaintiff Rebecca Scofield submits this statement of undisputed material facts along with plaintiff's motion for partial summary judgment. So, Professor Scofield is an associate professor of history and a department chair at the University of Idaho. That fact is found in the Declaration of Rebecca Scofield. So, defendant Ashley Guillard is a resident of Texas. Professor Scofield served Ms. Guillard with discovery requests, including requests for admission pursuant to Rule 36 on July 20th, 2023. That's from the Declaration of Wendy Olson, Exhibit A, which we will look at next briefly. Under the Federal Rules of Civil Procedure, Ms. Guillard's responses to those discovery requests were due on July 20th, 2023. To date, Ms. Guillard has not responded to plaintiff's requests. Olson Declaration. Ms. Guillard has never been to the state of Idaho. Ms. Guillard has never been to Moscow, Idaho. In the early morning hours of November 13th, 2022, 4 students at the University of Idaho were murdered in a home near the campus. Professor Scofield did not personally know any of the victims. That's from Scofield Declaration. At the time of the murders, Professor Scofield was not in Idaho. On or about November 22nd, 2022, Ms. Guillard began uploading and posting videos to the social media website TikTok addressing the murders at the University of Idaho. That's citing ECF 20. So ECF 20 was Ashley Guillard's answer. So the reason I'm mentioning the citations in the statement of facts is so that you see the variety of places, the variety of pleadings, the variety of discovery that the statements of fact are coming from. Because remember, Rule 36 or Rule 56, summary judgment, procedures, supporting factual positions. A party asserting that a fact cannot be or is genuinely disputed must this is going to be basically the same for the party asserting the fact, but this says so a party asserting that a fact cannot be or is genuinely disputed must support the assertion by citing to particular parts of materials in the record, including depositions, documents, electronically stored information, affidavits or declarations, stipulations, including those made for purposes of the motion only, admissions, interrogatory answers, or other materials, or by showing that the materials cited do not establish the absence or presence of a genuine dispute, or that an adverse party cannot produce admissible evidence to support the fact. So so basically, these are the places where the facts are pulled from. So going back to the statement of facts, in her TikToks posted on or about November 24th and thereafter, Ms. Guillard made numerous statements that Professor Scofield was involved in the murders. In a TikTok posted on November 26th, 2022, Ms. Guillard stated, inter alia, that there were two people who partnered to kill the 4 University of Idaho students, Rebecca Scofield and J.D. In a TikTok posted November 28th, Ms. Guillard stated that, I don't care what y'all say, JD and Rebecca Scofield killed the students. Rebecca was the one to initiate the plan and hired JD. In a TikTok posted November 28th, Ms. Guillard stated that Professor Scofield's decision to have the students killed was based on her connection to one of the students. In a TikTok posted December 1st, Ms. Guillard stated that she was not worried about Rebecca Scofield suing me. She ordered the execution, the murder of the 4 students. In a TikTok posted December 2nd, 2022, Ms. Guillard stated that Rebecca Scofield is going to prison whether you like it or not for killing the 4 students. Ms. Guillard's statements that Professor Scofield was involved in the murders were false. That's citing Olson Declaration and the request for admissions, number 4. Ms. Guillard has admitted that her statements that Professor Scofield was involved in the murders were false. Also, request for admission 4. The only basis for Ms. Guillard's statements that Professor Scofield was involved in the murder was Ms. Guillard's spiritual research, intuition, and instincts. Admission 6. Ms. Guillard was not aware of any physical evidence linking Professor Scofield to the murders. Ms. Guillard had no written information and did not receive any information orally from another human being that showed Professor Scofield ever met the students. The University of Idaho has no records of the students ever being enrolled in a class taught by Professor Scofield. And that's going to be Exhibit N, which is... Hey, it's the subpoena to produce documents. Basically, Professor Scofield subpoenaing the University of Idaho. In her TikToks, Ms. Guillard also made numerous statements that Professor Scofield was romantically involved with a student, one of the students who was murdered. In a TikTok posted November 28th, Ms. Guillard stated that Rebecca Scofield and the student's connection is the reason for Professor Scofield ordering the murder. In a TikTok posted December 5th, Ms. Guillard stated that Rebecca Scofield was being a sugar mama to the student, that the pair were on a break, and that during the break, Professor Scofield was worried about being caught, and that's when she started planning her murder. In a TikTok posted December 5th, Ms. Guillard stated that Professor Scofield's relationship with the student was filling Rebecca's need for a woman. In a TikTok posted November 25th, Ms. Guillard stated that there was a specific university policy that Professor Scofield was worried about violating if people found out she was dating the student. Ms. Guillard's statements that Professor Scofield was romantically involved with the student were false. Ms. Guillard has admitted that her statements that Professor Scofield was romantically involved with the students are false. The only basis for Ms. Guillard's statements that Professor Scofield was romantically involved with the student was Ms. Guillard's spiritual research, intuition, and instincts. Ms. Guillard had no physical evidence showing that Professor Scofield had a romantic relationship with a student. Ms. Guillard's TikTok account had thousands of followers, and some of her TikToks defaming Professor Scofield had thousands of likes, indicating that a third party had viewed the video and liked it. And that's Exhibit O. Which, hey, it's a screenshot of her TikTok. And so, the following crimes are punishable by imprisonment in the state of Idaho: murder, manslaughter, and criminal conspiracy. We looked at those earlier in a footnote. Solicitation of a crime is punishable by imprisonment in the state of Idaho. An accessory to a crime is punishable by imprisonment in the state of Idaho. So those are undisputed facts that, the crimes Ashley Guillard accused Professor Scofield of being guilty of are punishable. They're felonies in the state of Idaho. An accessory to a crime is punishable by imprisonment in the state of Idaho. On November 28, 2022, plaintiff's counsel sent a cease and desist letter to Ms. Guillard, notifying her that she had made false and defamatory statements regarding Professor Scofield on TikTok, and demanding that Ms. Guillard immediately remove all such false and defamatory statements from TikTok and immediately cease and desist from making or publishing similar TikToks or false statements on any other public platform. Ms. Guillard received and read that letter. Nevertheless, Ms. Guillard continued to state publicly that Professor Scofield was involved with the murders of the students and that she had an affair with one of them. On December 8th, plaintiff's counsel sent a second cease and desist letter to Ms. Guillard, reiterating that Ms. Guillard had made multiple false and defamatory statements regarding Professor Scofield. Ms. Guillard received and read that letter. Nevertheless, Ms. Guillard continued to state publicly that Professor Scofield had an affair and murdered the students because of it. On December 27th, The Moscow Police Department issued a press release related to the murders, stating, "At this time in the investigation, detectives do not believe the female associate professor and chair of the history department at the University of Idaho suing a TikTok user for defamation is involved in this crime." I mean, they don't name her, but they describe her to the point that there's only one person in the world that they could be describing. That's Professor Scofield. The University of Idaho maintains a faculty staff handbook containing policies governing the conduct and behavior of professors, including Policy 3205 concerning consensual romantic or sexual relationships and Policy 3220 concerning sexual harassment. Policy 3205 provides that it is the policy of the University of Idaho that no employee shall enter into or continue a romantic or sexual relationship with a student or employee over whom she or he exercises academic, administrative, supervisory, evaluative, counseling, or other authority. Policy 3220 provides that the University of Idaho condemns sexual harassment and defines sexual harassment as including behavior that overtly or covertly uses the power inherent in the status of a professor, teacher, or other officer to affect a student's educational experience or career opportunities by intimidating, threatening, or coercing the student to accept sexual advances or risk reprisal in terms of a grade, a recommendation, an opportunity for professional growth, or a job. A University of Idaho professor found to have violated Policy 3205 is considered to have committed unprofessional conduct and may be subject to discipline up to and including dismissal. Policy 3205 further provides that a romantic or sexual relationship of the kind forbidden by the policy inevitably raises concerns for objectivity, fairness, and exploitation. Because they have the potential for abuse and damaging consequences, the imbalance of power creates unacceptable risks of exploitation, favoritism, harassment, and bias, both actual and perceived, and thereby impairs the integrity of the professional relationship and the trust on which it depends. A University of Idaho professor found to have violated Policy 3220 is subject to immediate and appropriate corrective measures, including disciplinary action commensurate with the scope and severity of the occurrence. Such disciplinary action may include, but is not limited to, warning, reprimand, demotion, suspension, or dismissal with notation in the personnel file. So that's the statement of undisputed material facts. We have the declaration of Wendy Olson. Basically, she's saying, hey, all these exhibits I filed are true and correct copies of that information. Then we have the declaration of Rebecca Scofield in support of plaintiff's motion for partial summary judgment. So she is a professor. In late 2022, she was informed of the defamation, basically. Same. Ms. Guillard's statements are false. So this is her sworn, Professor Scofield's sworn statement saying, this is false. And then you have Ashley Guillard's admission that, yeah, these are false because she failed to deny them. I have never been in a romantic relationship with any student at the University of Idaho. That includes KG. I was not involved in any of the murders. I did not plan the murders. I never met the students. I never taught the students. None of them were ever in a class I taught. I did not personally know the students. I was not in Idaho when the murders occurred. Rather, I was in Portland, Oregon, visiting friends with my husband. We checked out from our hotel in Portland on the morning of November 13th, after the murders had already been committed, and we did not arrive back in Idaho until well after they had been discovered and reported to law enforcement. Attached here too is Exhibit A, is a true and correct copy of the university's policy, and Exhibit B is the other policy. And I declare this under penalty of perjury. And now, get ready. This is your warning. This is your warning. If you need a scotch, go get a scotch. If you need something harder and it's legal, do it now. It's gonna get rough. Because now we're reading Ashley Guillard's opposition to the motion for partial summary judgment. Like I said, I haven't read it. I've only glanced at it. I only know one of her arguments. It was in her last document we read. It's bad. It's really bad. Frankly, it's insulting. But there you go. Everything she does is insulting. So, you have your whiskey. Let's go. Comes now. Defendant Ashley Guillard in opposition to plaintiff Rebecca Scofield's motion for partial summary judgment. This litigation is a matter of determining the truth of the matter, whether or not Rebecca Scofield caused the murder of the 4 University of Idaho students found slain on November 13th, 2022. No. The truth of the matter is whether you defamed Professor Scofield. That's what this litigation is about. It's a matter of determining the truth of whether you defamed her. Now, yes, truth is a defense. So if you can prove that Professor Scofield is the murderer, that's a relevant fact, but that's not the ultimate fact. The ultimate fact is, did you defame her? At least that's the ultimate question, I should say. So it is also important to determine if the court has subject matter jurisdiction over the plausibility of spiritual belief and practices, which was brought into question by Docket 50 on August 21st, 2023. No, the court doesn't have to determine subject matter on that, period, but it also doesn't have to decide the plausibility of spiritual beliefs and practices. It just has to say whether you had a reckless disregard for the truth. That's it. That's it. Lastly, it is also important to determine if spiritual messages give rise to a cause of action for defamation. Once again, your spiritual messages don't matter. They don't matter at all. You're not being sued over your spiritual messages. You're being sued over your TikTok videos asserting that Professor Scofield is a murderer and an adulterer. That's what you're being sued over. I've said this many times already. If you just did the TikTok reading in your home and said, looks like she's the murderer, you wouldn't be sued. It wouldn't matter. The court wouldn't care. But now, because you made over 100 TikToks about it, confidently asserting that Professor Scofield's the murderer, that is the issue. That's the issue. The fact that your only evidence comes from your spiritual practice, that's a problem for you. Because you don't have any real evidence. You don't have any factual evidence. Frankly, you don't have any evidence at all because you've admitted to everything. You have admitted that Professor Scofield is not the murderer, because your failure to admit or deny in the request for admissions, you have admitted that Professor Scofield did not commit the murders. So, because you have admitted that she did not commit the murders, your spiritual practice is irrelevant because you have admitted that she did not commit the murders. You have published that she did not commit, or well, you have published that she did commit the murders and admitted that she didn't. Therefore, you published defamatory material, which is false because you admitted it's false. There is no question. I mean, there is nothing important to determine. You list these three things that are important to determine, but there is nothing to determine other than the amount of damages at trial, because you've admitted everything else. There is, as far as liability, there is nothing to determine. That's why we're at summary judgment now. So none of the above has been determined. Well, two of those don't need to be determined, but even if they did, you've already admitted. So sucks to be you. Additionally, defendant Ashley Guillard has never admitted to defaming plaintiff Rebecca Scofield. Instead, she has continuously argued that this litigation was brought illegally in bad faith to avoid Rebecca Scofield from being properly investigated for ordering the murder of victim Kaylee Gonzalez and the remaining 3 students. But under the rules of civil procedure, under the rules that govern litigation in federal court, you have admitted conclusively to defaming Professor Scofield, or at least you have admitted to all of the elements. Therefore, you have admitted to the defamation itself. So you may say right here that you have never admitted to defaming Professor Scofield, except you have. For all intents and purposes, you functionally have admitted conclusively. Unless the court doesn't hold you to the standard it should, which, remember, we looked at that whole section on the procedural history of this litigation in the motion for summary judgment, specifically to remind the court, you need to start holding her to the standard that you should. She may be pro se, but that's not a get out of jail free card. That's not an incompetence waiver. Her pleadings don't have to be artful. Her pleadings need to be construed liberally, but she needs to be held to the rules like any other litigant. And those rules say she has admitted to everything. This litigation has been complicated by the courts and the public's ignorance on the plausibility of tarot readings, spiritual connections, and spiritual beliefs. Defendant Ashley Guillard has evidence that she and her spiritual messages are reliable sources. For example, Ashley Guillard conducted an intuitive tarot reading for someone on March 8th, 2023. It predicted the upcoming death of the person's husband, who was otherwise healthy and young. So, do you know what this isn't? Good evidence. I mean, she conducted a tarot reading for someone. What? And what? Whoa! Look at that! Look at that! Look at that! We have statement. statement. We have the declaration by Attorney Olson, declaration by Professor Scofield, and all these exhibits. Where's the exhibit? Where's her declaration? Where's her declaration? She's asserting that she did an intuitive tarot reading for someone. Where's the declaration? Where's the exhibit? I don't know. Doesn't exist. But it predicted the upcoming death of the person's husband who was otherwise healthy and young. Although the defendant hoped it wouldn't come true, the husband died on October 24th, 2023. See Exhibit A. Oh, maybe her exhibit is attached at the bottom. On YouTube, that predicted the death of Staff Sergeant Kenyon White. And facebook.com/kenyon.warmachine.white. So, Staff Sergeant Kenyon War Machine White, an otherwise healthy and young staff sergeant in the military. What's a dangerous job? The military? Do I know? Well, first off, I don't know that he died. I don't know that this is true. But it's like, the thing about psychics is you go off of what you know about someone. So, you know that Staff Sergeant Kenyon White is in the military, and let's say he's deployed somewhere, and it's like, well, he's about to die. It's really going out on a limb there. Not saying, the U.S. military has a relatively low incidence of soldier death as a percentage, but it's still one of the more dangerous occupations. So, but thus, because Guillard has experienced confirmation of the reliability of her intuitive tarot readings for the past 4 years, she has reason to believe that the messages she received about Rebecca Scofield are substantially true. So, based on evidence of one, she got it right once. Therefore, everything's true. Show us one crime you've solved before the police solved it. Show us one. Show us one. Scofield and her attorneys have continuously lied about Ashley Guillard in every legal document they filed in this civil complaint, explained more fully below. For example, in docket 56, plaintiff's motion for partial summary judgment, attorney Wendy Olson made a false statement that Ashley Guillard posted content about the murder of the students to make money. Attorney Wendy Olson published that lie about Ashley Guillard, knowing it was false because she has documents from TikTok provided to her after her subpoena dated June 20th, 2023, proving that defendant Ashley Guillard did not make any money by posting content on TikTok. Do you know what? Even if this is true, it doesn't matter. It does not matter one bit. Defamation doesn't say, that one of the elements of defamation isn't, did the defendant make money off of their defamatory statements? So it does not matter one bit if she made money off of the TikTok. But here's the thing. Here's the thing. Let's look at the answer. Let's look at her answer. What am I looking for? Why did I do that? I hit the wrong button. Control F and okay. Ashley Guillard was deprived of her good reputation, business, clients, income, a peaceful social media presence, family, and friends due to the counterclaim defendant's frivolous claim and defamatory statements about her. She's claiming financial damages. She was trying to claim financial damages. One would think that her TikToks were making her money. Her psychic practice was making her money. Whether that's coming from TikTok or from people she charges money to do the tarot readings. So Professor Scofield notably did not say Ashley Guillard has made money from the TikTok affiliate program, but no, she says if it says she made money off of her TikToks, it's she's a professional psychic. That's what the allegation was. She's a professional psychic, whether it comes from the TikTok affiliate program or from charging people to do the psychic readings. But that's still all irrelevant. Does not matter. Attorney Wendy Olson also promulgated several lies about Ashley Guillard in multinational news media. Additionally, Guillard has reason to believe this entire complaint was filed fraudulently and frivolously. As a matter of law, and as punishment for continuous judicial misconduct and severe perjurious statements and documents, defendant Ashley Guillard requests the court to deny the plaintiff's motion for summary judgment and to heavily punish the plaintiff and her counsel with sanctions. That's ridiculous. Relevant background, factual history. On November 13th, 2022, 4 students at the University of Idaho were murdered at a home near campus, referred to as the 4 students. On November 23rd, 2022, upon request of a TikTok user, Ashley Guillard began conducting intuitive tarot readings to get answers on who, what, why, and how the 4 students were murdered. The intuitive reading revealed that Rebecca Scofield hired a male student to murder the 4 students. During the evening of the murders, she sent another male to make sure the murders were committed. Ultimately, one of the men left because the original male took control over the situation and committed the murders. Scofield hired the men to kill the students to protect her reputation. She feared she'd be exposed for having an affair with one of the female victims. On November 28, 2022, Guillard received a demand letter by email demanding that she cease posting videos about Scofield. Guillard refused to follow the demands because she believed that she was telling the truth and that she was protected by the substantial truth doctrine and the First Amendment of the United States Constitution. Notwithstanding the fact that Guillard was telling the truth, on November 21st, 2022, Scofield and her attorney Wendy Olson illegally filed frivolous complaint, Scofield versus Guillard, in federal district court for the District of Idaho. They subsequently lied on Ashley Guillard in every legal document they filed in the complaint to prevent Scofield from being suspected and investigated for the murder of the 4 students. And it's absolutely ridiculous. Like, if the police actually suspected Professor Scofield of being the murderer, they'd investigate her and they'd charge her, regardless of her litigation in a civil matter with some rando in Texas. This isn't a way to cover it up. I mean, the reality is, if she committed it, the best action might be to ignore it rather than draw more attention to it through litigation. Hope that eventually Ashley Guillard starts chasing another, clout arena, that the next murder takes up all her attention. It wouldn't be a good strategy to sue her and keep the story going for the next year if you committed the murders. But since Professor Scofield didn't, and she was defamed and damaged, this is the way to be made whole. Recent history. It is the discovery phase of the litigation. To prevent defendant Ashley Guillard from obtaining physical evidence, the plaintiff and attorney Wendy Olson filed a motion to quash the summons Guillard served to Meta Platforms. Additionally, a motion to dismiss the complaint due to fraud, lack of subject matter jurisdiction, and lack of personal jurisdiction is pending. The motion for partial summary judgment was inappropriately filed while the defendant sought evidence and due process. The motion was filed with the intent to impede upon due process for Ashley Guillard. That is stupid. I get so tired of people yelling and screaming, due process, I haven't been given due process. When am I going to get my due process? Sovereign citizens on the side of the road. You can't give me a ticket because of due process. It's like, but this is the process. If summary judgment were a violation of due process, it wouldn't be in the rules of procedure. Courts would have chucked it ages ago. But it is in the federal rules of civil procedure. It doesn't say you can't bring a summary judgment motion until after discovery has closed. It doesn't say you can't bring a motion for summary judgment while the opposition has a motion to dismiss pending. The truth of the matter is, this is a properly filed motion for summary judgment. And once again, to prevent defendant Ashley Guillard from obtaining physical evidence, plaintiff and attorney Wendy Olson filed a motion to quash the summons Guillard served to Meta Platforms. But you haven't responded to any of the requests for discovery. That's why we're here. That's why you've deemed everything admitted, because you didn't respond. I'm guessing you haven't done the requests for documents or requests for production. Or the interrogatories. And as the court said, your first step shouldn't have been subpoenaing Meta Facebook in the first place. This should have been a request for production of documents to Professor Scofield. That should have been your first avenue. If what you received, if you thought you didn't receive everything you were entitled to, then maybe a subpoena would have been in order. But just saying, hey, I don't think I would have got anything in the first place, therefore I went with my own procedure. And then complaining, they're hiding evidence. they're not hiding evidence. You're going about it the wrong way, and the court rightly told you not to. Told you you can't. But you're hiding evidence, Ashley Guillard, because you didn't respond to the discovery requests. Sucks to be you. So, legal standards and argument. Substantial truth is a defense. Scofield has not proven that the statements Guillard made about her were false. The complaint and subsequent filings by the plaintiff relied on the court to ignorantly deem Guillard's spiritual practice as implausible. The court's ignorant now, is it? I take it she hasn't read How to Make Friends and Influence People. Calling the court ignorant is not on that list of how to make friends and influence people. I also haven't read it, but whatever. However, as proven by Exhibit A, the War Machine staff sergeant, that was mentioned in the introduction, Guillard's intuitive messages are reliable. Exhibit A is an intuitive tarot reading conducted by Guillard by request of a concerned wife. She wanted insight on her marriage and potential threat of divorce. Even though we did not ask, the reading revealed the husband was about to die and that the wife would not expect it. Unfortunately, 7 months later, her husband, Staff Sergeant Kenyon White, died by suicide. Oh, so he's young and healthy, therefore we won't expect suicide. But he's in the military, which unfortunately suffers from a very high rate of suicide. So once again, this isn't psychic. This isn't validation that, you know, her tarot readings are right. It's that she took the information she had. He's in the military. The military has a high rate of suicides. Therefore, I'll say he's gonna die soon. And if he does die soon, wow, look, I'm right. That's validation. If he doesn't die soon, what's the wife gonna do? Sue me? I read the cards wrong. You know, that there's been something intervening that has changed the outcome. I mean, it's just ridiculous. Guillard received confirmation of the reading from the wife as she was seeking more answers pertaining to her husband's death. And what else did you say in this? What I'm sure the husband's death wasn't the only thing. Has there been anything you got wrong in this reading? In other readings? Do you, Ashley Guillard, have a 100% positive reading rate? Is your accuracy unquestioned? 100% accuracy? No? Is this the only accuracy you can name? So you're 1 for 1,000, 1 for 1,000,000? But this one, that proves everything. It proves everything. Even though you've already admitted you have no evidence, Professor Scofield didn't commit the murders. Professor Scofield wasn't in an affair with a student. But, you know, you got this one right, maybe. Guillard has evidence of the accuracy of her intuitive tarot readings. They cannot be deemed as implausible on its face. Therefore, it is possible that the message Guillard received about Scofield is likely to be true. Because criminals are likely to lie about their crimes, the truth is a matter of time, resources, and discovery. Are charlatans likely to lie about their charlatanry? In alignment with typical criminal behavior and intent to hide their involvement in crimes, the plaintiff and attorney Olson has blocked discovery attempts to get evidence regarding the connection Scofield had with the victims and with the alleged co-conspirators of the murders. They also omitted information from the University of Idaho subpoena. Attorney Wendy Olson strategically omitted requests for all communication between Professor Scofield, the 4 students, and alleged co-conspirators. If you want that, you subpoena the University of Idaho. They subpoenaed what they felt they needed. They subpoenaed what they wanted. If you think other information exists, you subpoena the University of Idaho. You request from Professor Scofield all of her emails with the students. You ask for it. Professor Scofield and her attorneys not conducting discovery in the way you think they should isn't a conspiracy against you. It's not a conspiracy against you. It's not evidence. The way they conduct discovery isn't evidence that Professor Scofield committed the crimes. If you want information, you need to conduct discovery to get it, if you can. You can't rely on the opposition to do discovery for you, and then tut-tut if they don't do it the way you wanted them to. Instead, she only sought communication that Scofield taught a class that the students were enrolled in. Guillard has not alleged that. And communication regarding an investigation. Guillard has not alleged that. Due to the strategic lies, omission, misinformation, and manipulation by Scofield and Olson, the defendant must subpoena the University of Idaho for the correct information. Then why haven't you? Why haven't you? Professor Scofield has already been able to subpoena the University of Idaho. I mean, you probably shouldn't have even waited to know what was in her subpoena. You should have just done it. You should have been assertive. You can't wait until Professor Scofield does her motion for summary judgment and then say, whoa, wait. They didn't do discovery. They didn't do their discovery the way I think they should. Therefore, I'm now going to have to do my discovery. Therefore, summary judgment isn't proper because I sat on my ass and didn't do it yet. I didn't do my discovery. Therefore, I don't have any facts to contradict them. Therefore, there are no unopposed facts. Therefore, summary judgment is proper. If this is information you wanted, if this was the gotcha, you should have gone for it. You shouldn't have relied on your opponent to do it for you. That's stupid. That's lazy. And frankly, using this as a defense to summary judgment is dishonest. It's disgusting. It is still a matter of discovery and the investigation to expose the communication between Professor Scofield, the 4 students, and alleged co-conspirators. The document provided by the University of Idaho admits they never investigated the claims. Scofield has not proven that the statements Guillard made are false. Furthermore, she and attorney Wendy Olson strategically blocked Guillard from evidence that the statements she made are true. Therefore, the plaintiff fails to prove defamation, which requires a false statement to be made. Number one, she has proved the statements are false. The rules of civil procedure demand that the court accept, because you didn't refute them, you didn't deny them. That's on you. It's also on you that you didn't conduct your discovery. You didn't subpoena the University of Idaho. I mean, they didn't block you from subpoenaing the University of Idaho. They didn't block you from getting the evidence you want from the University of Idaho. They just didn't get it for you. They didn't get it for you. It doesn't work that way. It does not work that way. So, Scofield fails to meet elements 2 and 3 of the defamation claim. Except element 3 doesn't matter because they're claiming it's defamation per se. And they brought the goods to show this is defamation per se. The elements of a defamation claim applicable here are as follows. He must prove that 1. Garner communicated information about him to others. I mean, first of all, you're doing a direct quotation. Use quotation marks. Second of all, even if you are doing a direct quotation, don't leave the name of the party from the case you're citing when you're citing the rule. In brackets, put plaintiff communicated information to others, or defendant communicated to others, sorry. This is just sloppy work. So, but Garner communicated information about him to others. 2, the information was defamatory. And 3, he was damaged because of the communication. That's citing Clark versus Spokesman Review, 2007, which itself cites Goff versus Tribune Journal, Idaho, 1952, and C. Sadid versus Vilas, Idaho, 2013. Scofield and attorney Wendy Olson failed to prove that Guillard made false statements. Therefore, they have not proven defamation required by the second element. Additionally, admits to not being investigated by the University of Idaho nor Moscow Police Department, nor has she proven any damages to her reputation. She has not lost any wages, employment, or opportunities. Instead, she gained in popularity. Thus, Scofield fails to meet the third element, which requires reputational harm and damages. Therefore, her request for a summary judgment must fail. But once again, that doesn't matter because to win this summary judgment motion, she doesn't have to prove damages. It's defamation per se. Why don't you tell us why this isn't defamation per se? You can't. I'm shocked. But next, the complaint is barred by qualified privilege. It's not. Guillard conducted the psychic investigation and exposed the results online because she wanted to help solve the murders. No, she did it because she's a clout goblin, and she wanted the clout circus to increase her viewership on TikTok. She doesn't give a damn about helping solve the murders. She's a clout goblin. That's what she wanted. An intuitive reading revealed that Scofield would get away with murder if Guillard did not get involved. Therefore, Guillard posted the information she gathered from the intuitive tarot readings online for exposure. Guillard did not know how she could make a positive impact on the case of the murder of the 4 students as an outsider. She posted the content with the intent of exposure so that she could get the attention of the investigators and help solve the case. The judicial privilege immunizes a party from civil liability for statements made during judicial proceedings. See Berrien versus Berberian, Idaho 2020. Idaho has long recognized that defamatory statements made during a judicial proceeding are absolutely privileged. The purpose of the judicial privilege is to keep the paths leading to the ascertainment of truth as free and unobstructed as possible. We went over this before because she tried to do this in her motion to dismiss. So we have a preview of Professor Scofield's reply brief on the summary judgment motion. And it's the exact same argument I made before I saw Professor Scofield's argument in the motion to dismiss. Well, the opposition to the motion to dismiss. So before we keep reading, she's arguing that, hey, there was a criminal investigation ongoing. Therefore, I'm privileged. My TikToks were privileged because there was a criminal investigation ongoing. There's a criminal trial. There's criminal proceedings that share some of the facts of this case. Therefore, anything I said, because there is criminal proceedings ongoing, it's privileged. It's privileged. Even though there was no proceeding involving you and Professor Scofield, you are not involved. Professor Scofield was not involved in any litigation until this litigation. So you are not the state of Idaho. You do not bring criminal charges. You do not conduct criminal investigations. You are not the defendant. Nothing you said was privileged. But funny enough, she tried to countersue Professor Scofield in spite of this privilege. It was, you defamed me by suing me, therefore I sue you. But that didn't work for her. Now she likes that privilege, even though she's misapplying it. It's almost like looking at delete laws when, I'm suing Kate Peter and Josh Abrams for copyright infringement. Therefore, I can get YouTube to strike every single video. And the other party's counter notification is irrelevant because I'm involved in copyright litigation, just not against that other party or concerning that specific video or anything else. But I'm able, it counts, even though it's a different proceeding, different facts, different everything. Or also delete laws, Martinez versus United States, or U.S. versus Martinez or Rodriguez. I think it's Martinez. You can't extend this traffic stop. You're making me extend it. And besides which, detaining you isn't extending that traffic stop. It's a completely separate police interaction. But, same logic here. Same logic here. The police were investigating Brian Kohberger for the murders. Therefore, anything I said is privileged because the police, who are not me, were investigating someone else than Professor Scofield. Therefore, she can't sue me for saying she's the murderer. That's offensive. So, this privilege sets a low bar, requiring only that the defamatory statement, 1, be made during a proceeding, and 2, have a reasonable relation to the cause of action of that proceeding. That's citing Dickinson Frozen Foods Inc. versus J.R. Simplot, Idaho 2019. Let's see. I thought for sure that Professor Scofield would have had that citation in her opposition to the motion to dismiss. Either way, defendant Ashley Guillard's statements about Rebecca Scofield's alleged involvement in the murder of the 4 University of Idaho students were made during judicial proceedings, specifically during the investigation of the murders. Oh, no. I was wrong. It wasn't in the motion to dismiss. It was Ashley Guillard brought it up in her opposition to the motion to quash the Facebook subpoena. So Professor Scofield previewed her argument in the reply. That's where it was. So let's search the reply. Either way. Although Ashley Guillard is not a party in the criminal case, she sent her findings to the FBI tip line as a witness to help solve the case. And yet, you're not being sued for sending your tip to the FBI tip line. You're being sued for your TikTok videos, which have absolutely nothing to do with the criminal investigation. Sending a tip to the FBI probably isn't publication for the purposes of defamation. Publishing 100 TikTok videos is. So therein, her statements easily meet the standard of judicial privilege, and the plaintiff fails to state a defamation claim. Additionally, pursuant to Berrien versus Berberian, statements to law enforcement for the purpose of initiating criminal proceedings are entitled to a qualified privilege for all torts except malicious prosecution. Once again, you're not being sued for your statement to law enforcement. Therefore, the defendant Ashley Guillard's statements on social media are also privileged due to the reasonable relation to the pending criminal case of the murder of the 4 University of Idaho students, pursuant to Berrien versus Berrien, Idaho 2020. Thus, the complaint fails to state a claim for relief and must fail. It is also in the interest of justice to dismiss the complaint. Oh, just throw that in there. It's in the interest of justice. Wow. Then it's got to be dismissed then. Fraudulent litigations are not entitled to respect. Let me repeat that. Fraudulent litigations are not entitled to respect. So says Ashley Guillard. The plaintiff's argument that Guillard's lack of response to the request for admission conclusively establishes the material facts. However, Guillard has not received the requests. To date, she is not sure if it was sent by email or mail. Allegedly, it was sent June 20th, 2023, when Guillard was in New York. But where? The plaintiff likely failed at properly communicating with Guillard at an attempt to get a default judgment. This isn't a default judgment. This is summary judgment. I hereby certify that on June 20th, 2023, I served a copy of the foregoing via email as follows. Ashley Guillard, at her email address, signed Wendy J. Olson. So you haven't received the requests. Check your email. It's at that email address. Check it. That there's a certificate of service. You not checking your email isn't a defense. You being in New York isn't a defense to not checking your email. I mean, she's just unbelievable. But, you know, those dastardly attorneys emailed me in an attempt to get a default judgment. Guillard believes the complaint and subsequent filings are fraudulently filed. She also believes the judicial proceedings have lacked in due process and judicial impartiality and are entitled to no respect whatsoever. In Griffin versus Griffin, Supreme Court case from I don't know what year, a pro se litigant won his case in the Supreme Court, who stated, "A void judgment is a nullity from the beginning and is attended by none of the consequences of a valid judgment. It is entitled to no respect whatsoever because it does not affect, impair, or create legal rights." In spite of her not properly citing this, I remember this from her motion to dismiss. This is a case from like 1865 or 1835, or either way, it's from the 1800s. It might actually still be good law, but she says a void judgment is a nullity. How do you determine something is a void judgment? You don't just get to say, this is a void judgment, therefore go away. Probably you're going to have to appeal and get a higher court to say, yeah, of course there was no personal jurisdiction, therefore this is a void judgment, so reversed and remanded. But you know, you don't get to determine this is a void, you know, this is a nullity. This proceeding is entitled to no respect whatsoever, therefore I don't have to participate in good faith. That's not how it works. And for some reason, she cites Ex parte Seidel from the Texas Criminal Appeals Court. And then Ex parte Spalding, probably also from the Texas Criminal Appeals Court. She doesn't tell us. And it's a concurring opinion. But she doesn't tell us anything about those ones anyway. Not that it matters, because they're barely persuasive. Who cares what the state court of Texas says in Idaho federal court? Guillard believes Scofield ordered the murder of the 4 students and filed this illegal complaint against Guillard to avoid suspicion. Scofield and her attorney subsequently used the court and news media to humiliate Guillard, mock her spiritual beliefs, and lie on her in every filing. Poor light on Ashley Guillard. Did that mean college professor humiliate you by saying that the same mean professor isn't a murderer? Because once again, for some reason, saying I'm not a murderer is somehow defaming you and humiliating you. But you calling Professor Scofield a mass murdering adulterer, that's perfectly fine. That's not humiliating. That's not humiliating. I said it, so it's got to be true. And, you know, she sucks anyway, so what does it matter? God, I hate her. Ashley Guillard. In the complaint, Olson made a false statement that Ashley Guillard decided to use the community's pain for her online self-promotion. The truth is, Guillard used her talent to find out what happened to the 4 students and others. Scofield and Olson made a false statement that Scofield had never met any of the victims, let alone entered a romantic relationship with them. This is not an undisputed fact. It is a matter of discovery. And yet, you don't have a fact to dispute it with. Therefore, it's an undisputed fact. This isn't I mean, you can't have a competition of the facts. Remember the Venn diagram. You have no facts in your Venn diagram, so it's just a circle provided by Professor Scofield. But even if you had denied it, this is still just a conclusory statement. This is still just a conclusory statement. You have not brought any facts to dispute it. So it is an undisputed fact, because you need more than just a conclusory statement to dispute the fact. You need a declaration at the very least. And your declaration saying Professor Scofield met them, what's that based on? What's that based on? Nothing. Professor Scofield still wins. And you say it's a matter of discovery. You haven't discovered it. You haven't attempted to discover it. You're saying they're impeding you from discovery by not doing discovery for you. They didn't prevent you from issuing a subpoena to the University of Idaho. You didn't do a request for production to Professor Scofield because you determined that it would be useless anyway. And then you have the gall to come here and say, well, I didn't provide them the discovery that I was supposed to give them because apparently I don't check my email, but I didn't request any discovery from them because it would have been useless anyway. And this is all a grand conspiracy against me to obstruct this litigation. Therefore, the court should just accept my conclusory statements because that's all that really matters. I said it, therefore it's fact. I swear I didn't read ahead. I swear I didn't read ahead before the rant. I did not read ahead before the rant. However, attorney Wendy Olson did not ask the University of Idaho to investigate or to provide the communication proving this to be true. So it's a matter of discovery, but attorney Wendy Olson didn't ask for it. But you didn't either. I promise I didn't read that line before my rant. I mean, it's a matter of discovery, but they didn't discover it. The thing is, Professor Scofield knows she can make a declaration saying, yeah, I didn't know any of them. That declaration is sworn. She has sworn under oath that she didn't. So to the court, that is a fact from her personal knowledge. Her personal knowledge. She would know who she has communicated with. Personal knowledge, sworn fact based on her personal knowledge about herself. Ashley Guillard, on the other hand, she's got to discover it some way. And so she wanted Professor Scofield to ask for a discovery on something she already knew and could swear to. But Ashley didn't have to. I mean, she would have had to herself subpoena the University of Idaho saying, provide me with any and all communications between Professor Scofield and the students. And then she'd include that as an exhibit and have a declaration saying, I, Ashley Guillard, swear that this exhibit is true to the best of my knowledge and belief. And, this exhibit is the return of my subpoena from the University of Idaho. And it says this. She hasn't done that. Her failure to do that isn't Professor Scofield's fault. It isn't a fact in Ashley Guillard's favor in opposing the motion for summary judgment. It doesn't exist. Kind of like her evidence of Professor Scofield being a murderer. It doesn't exist. In docket 49, the court joined in the disrespect of Guillard's spiritual practices and beliefs, erroneously calling it implausible. During the hearing, docket 47, Judge Raymond E. Patrico empathized with Scofield and asked Guillard to consider how Scofield felt, notwithstanding the fact that Guillard believed Scofield to be a quadruple murderer. The frivolous complaint, perjurious filings, and lack of judicial impartiality, coupled with the court's lack of jurisdiction, deems the entire complaint void. Therefore, Guillard was not legally required to participate in the plaintiff's fraudulent attempt to harass her. The plaintiff's argument for a summary judgment must fail unless the order is for a complete dismissal of the complaint. The plaintiff's argument for a summary judgment must fail unless the order is for a complete dismissal of the complaint. But that's not what the summary judgment is asking for. The summary judgment is asking for victory, for a judgment in favor of Professor Scofield. The opposite of that is not dismissal, it's denying the motion, and the lawsuit continues. If Ashley Guillard wants a summary judgment order for a complete dismissal of the complaint, she needs to bring her own motion for summary judgment. Once again, you don't get to piggyback and ask for something completely different in your opposition to the summary judgment motion. Just like in the opposition to the motion to quash the subpoena to Facebook, she couldn't ask the judge to order Facebook. No, it was either grant the motion to quash or deny the motion to quash. An order forcing Facebook to comply with the subpoena, that's a separate motion. Same here. It's either grant the summary judgment motion or deny the summary judgment motion. Summary judgment on a different issue is a different motion. You need to bring that motion if you want dismissal on summary judgment. Not that you should bring it because, well, number one, you have a pending motion to dismiss, which was untimely filed, so it's going to be denied on those grounds and others. Well, maybe just on the untimely grounds. Courts are lazy. If they can deny it on one ground, why explore all the others? But it would be frivolous to bring a summary judgment motion because to dismiss, because frankly, there's all kinds of facts in Professor Scofield's favor. So you'd lose that one real quick. But so the complaint does not meet the standard for summary judgment. The summary judgment motion is what needs to meet the standard for summary judgment. The complaint needs to meet the standard of a complaint. You're not going to have all the facts for a summary judgment in the complaint. You just need enough to survive dismissal. You bring more through discovery, such as the unrebutted requests for admissions, which are deemed admitted. See, those weren't in the complaint, but they need to be considered in the summary judgment. So the complaint not meeting the standard of summary judgment, well, that's just silly, because a complaint shouldn't meet the standard for a summary judgment. It should meet the standard for a complaint. The plaintiff, Rebecca Scofield, and attorney Wendy Olson have blocked discovery attempts for Guillard to gather physical evidence. Ergo, the litigation is at an impasse and is not at an appropriate time for a decision. Additionally, Guillard alleges Scofield and Olson lied in every docket they filed with the court. But those are conclusory. You say they lied. You haven't brought evidence that they have lied. Guillard also believes that the statements she made regarding Scofield's relationship with one of the 4 students and regarding Scofield's involvement with the 4 murders are substantially true. But you haven't brought facts. Facts. The court does not care that you believe. The court cares about facts. Therefore, the plaintiff fails to meet the requirements of the law. In agreement with the plaintiff, summary judgment is appropriate when, viewing the evidence in the light most favorable to the non-moving party, there is no genuine dispute as to any material fact. That's Zetwick versus County of Yolo, 9th Circuit, 2017. The court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. Where the record is taken as a whole could not lead a rational trier of fact to find for the non-moving party. There is no genuine issue for trial, and summary judgment is appropriate. The district court must not only properly consider the record on summary judgment, but must consider the record in light of the governing law. And that's also Zetwick quoting Anderson versus Liberty Lobby, Supreme Court, 1986. The plaintiff's complaint, subsequent filings, and docket 56, motion for summary judgment, do not meet this standard. The court must deny the request for summary judgment. You say it doesn't meet the standard. How? How does it not meet this standard? You're just going to make a conclusion of law there and leave us hanging? Yikes. Conclusion. If Guillard's statements are read favorably to the defendant, it would read that she is believed to be telling the truth about Rebecca Scofield's role in the murder of the 4 University of Idaho students and Scofield's affair with Gonsalves. Additionally, the plaintiff has not provided any evidence that Guillard is not telling the substantial truth. Except she has. She has provided her own testimony through a declaration, sworn testimony. Also, she has your admissions because you didn't rebut them. I guarantee Professor Scofield, in her inevitable reply, is going to say Ashley Guillard is disingenuous when she says she never received the discovery request. She doesn't know how it was sent. The discovery request as Exhibit A or whatever it is has a why am I blanking? Clearly, I've been going too long today, but it has a declaration of service. It was sent to that email address. Ashley Guillard failing to check her email doesn't constitute an excuse. Therefore, give us what we want. Except they're going to, say it better than I just did, but it's 3 a.m. I'm tired. Scofield and Attorney Olson have continuously abused the judicial system. They filed the frivolous complaint, disrespected spirituality, Ashley Guillard, and her spiritual beliefs. They've lied in every docket they filed in the complaint to manipulate the court to believe lies about Ashley Guillard. They have blocked Guillard's attempts at obtaining evidence to prove she is telling the truth about Rebecca Scofield's role in the murders and relationship with the victims and conspirators. Now, they've filed a frivolous request for summary judgment. Whether or not the court has jurisdiction, and if the court impeded upon Guillard's right to judicial impartiality, is pending, docket 50. Discovery is still ongoing. For the aforementioned reasons, the request for summary judgment is inappropriate and must be swiftly denied. The court must deny the request for summary judgment unless it is for a complete dismissal of the complaint and punish Scofield and her attorneys with sanctions. Anything less is an impediment to judicial impartiality for Guillard. Prayer for relief. Award Ashley Guillard all court-related fees and sanctions pursuant to Rule 11C in the amount of $1 million pursuant to B. Chambers versus NASCO, Supreme Court, 1991. Footnote 3. Sanctions totaling nearly $1 million were upheld by the Supreme Court for the petitioner's attempt to manipulate the court of jurisdiction by acts of fraud, filing false and frivolous pleadings, and attempting by other tactics of delay, oppression, harassment, and massive expense to reduce the respondent to exhausted compliance. I discussed this last video because Ashley asked for $1 million last video. And my analysis stands. This is ridiculous. It's asinine. It's frankly, she's just increasing the odds of Professor Scofield receiving attorney's fees. So, 2, dismiss the action with prejudice due to failure to state a claim for relief pursuant to Rule 12b-6. And set aside Docket Order 49 pursuant to Rule 60b-4 and Rule 60b-6. This is this is hilarious. This wow. Wow. Do you guys notice something missing? Do you notice something missing? This is hilarious. This is this is good. This is good. Let's do the prayer for relief again. And before I tell you, you go to the comments. Tell me what is missing. What is missing from the prayer for relief? Because the prayer for relief, this is what Ashley Guillard is asking the court to do. Her prayer for relief. 1, award Ashley Guillard all court-related fees and sanctions pursuant to Rule 11C in the amount of $1 million pursuant to B. Chambers versus NASCO. 2, dismiss the action with prejudice due to failure to state a claim for relief pursuant to Rule 12b-6. And 3, set aside Order Docket 49 pursuant to Rule 60b-4 and 60b-6. Let's take a peek at the docket. 49 was the memorandum decision dismissing the counterclaims. So, last chance. Tell me what's missing. Okay. What she did not ask for in her prayer for relief is to deny the order for summary judgment. She didn't ask the court to deny Professor Scofield's motion for summary judgment. She didn't ask. She asked for 3 other things, but not to deny the motion. She didn't ask the court to deny the motion. I mean, she wants attorneys. Well, she wants fees. She's not going to get. She wants the court to dismiss the action with prejudice, but That's not the opposite. The opposite of granting the motion for summary judgment would be to deny the motion for summary judgment, not to dismiss. And setting aside docket order 49, well, that's also not, this isn't an operative motion for that. She wants sanctions, which she's not going to get, and two things that she can't even ask for in her opposition to the summary judgment motion. But she didn't ask for the court to deny the summary judgment motion. This is brilliant. And by brilliant, I mean, Ashley, you stupid moron. You didn't ask. How could you not have asked? I mean, is the court to say summary judgment granted as unopposed? This is so hilarious. And Exhibit A, tarot reading that predicted the death of Soldier Kenyon White with no declaration. So Exhibit A can't even be considered. It's not before the court. There's no authentication. Exhibit A does not exist. That was a fun one. I mean, as aggravating as the body of that motion was, this made it fun. This made it worth it. How could she not ask the court to deny the summary judgment motion? I mean, the summary judgment should be granted. Don't get me wrong. But she didn't even ask the court not to. So, with that, what I am going to ask you to do is like, share, subscribe, do all that fun stuff. And I will see you soon when I'm not quite this loopy from lack of sleep. So thanks for joining me. Bye-bye.